All righty then. So we are in Freedom Week, the court edition. We'll go over all things court. The main thing that I can stress to each of you is that the court system is absolutely positively different than the banking system, as well as is different than the federal government system in a way. Okay. Two of those actually do work together. So if y'all took our recording national status class, we told you guys to take those steps for a reason. You have to remove yourself out of their jurisdiction. Stop going in their jurisdiction, standing in front of them, telling me you ain't in their jurisdiction, but you're standing in their jurisdiction. Y'all got that? Like that don't work. Oh, I'm not in your jurisdiction. I'm the straw. No, it doesn't work that way. it don't work that way. Okay. So when you're attempting to get remedy from the court, you have to look at the courts for exactly who and what they are. Okay. First of all, they are a private company. They're private. They're not government. The courts actually run up under the governor, up under the state, which is given priority of all of the government contracts through sam.gov. So every court has a contract through sam.gov. How they played us was all their buildings look the same, right? Everywhere you go, it's like, well, this has to be government. The buildings look the same. Well, it's a government contract. And when you get a contract from the government, you have to build their buildings in the manner that they say, how they say it. So that's how they trick us. For example, if you damage a police car, you will not have state charges. You will have federal charges because they have a contract under the federal government that you grant funds that has to be accounted for, and that's actually government's property. Okay. So yeah, the courts are not government. So you can't go in there talking to them like they're government. You can't go in there talking about some constitution. They're not government. They're no different than the chain of McDonald's.
Nope.
They're not. So y'all know my philosophy and my goal is learn their rules, their policies, and beat them in their own game. And that's what we'll show you guys. To be able to, and depending on what stage of your court case you in, would depend on if you even need to walk in there, right? Caleb had to walk in for his court case because that was already a plea. He had plea, what, a year before then? Was it like a year?
Mm-hmm. It was
Okay,
one
so
year.
he signed a plea agreement a year ago. So if your question is, oh, I already pled guilty, can I get it overturned? Yes, you can. So he went back and rescinded the plea, utilized the tools that he have now, and ultimately fired the judge. He did not go to jail. He walked straight out because people asked, well, did he? Yes, he did. He walked straight out. And if you really paid close attention to that call, the main thing the judge kept saying was, there, when the sheriff come back, okay, now we didn't all been stepped in the court a couple times or once or however. I've been there before and ain't ashamed to say it, right? Have you ever seen a judge sit down and preside after everybody that stood up and say they swear to tell the truth, the whole truth, with nothing but the truth, so help you God? And the judge is sitting there without a sheriff. Never. You might not catch a court reporter, and I'll tell y'all why in a minute, but without a sheriff. So ultimately, Caleb, you can tell them what you did, how you took away their jurisdiction in the beginning. Yeah, you tell them yourself. How you on here?
Yeah, no. So what I did was I had made a plea. So I went in there and I had to put in a motion of rescinding my plea. And I explained to them all of the reasons why I should have never taken it in the first place, including the fact that at that time I was incompetent because I didn't know the law. And so I should have never taken it in the first place. Now, I also got that FOIA letter that says that you're not a citizen, and I filed that into the case. And after I filed that into the case, I also got a certified copy of the case information, and I put a 10-cent stamp on there, canceled out the 10-cent stamp, and then I had that filed back into the case as well. Before I went back in there and they were discussing my motion to withdraw the plea, and I was explaining to them, if you listen to the whole recording, one, that they don't have any jurisdiction. I explained to them specifically why they didn't have any jurisdiction. And when the judge was trying to get belligerent and not do her job, I fired her. And if you listen closer to the recording, you'll hear her say towards the end that we need to reset this, because once she was fired, she had no more authority over those proceedings. And she kept on trying to threaten me with contempt of court. And let me tell you, contempt of court is the biggest lie that they'll tell you. It's a bluff tactic. And they use that against people to see how much you know. Because when you understand that there's no such thing, you continue on after they say they're going to hold you in contempt, and they don't do a single thing. And if they did, according to both the rules of civil and criminal procedure, if you are arrested right there in the courtroom before a conviction and they charge you with contempt, you can get the case thrown out just like that. Because it specifically says in Rule 42 of criminal procedure under contempt, and it will be the same under civil, if they arrest you before you're convicted, that's a violation of your due process. And they lost their authority in that moment. So that's just another tidbit of information. But yes, I put in my case information with the 10-cent stamp. I filed my FOIA letter stating that I'm not a citizen, and I went in there and stood on it.
So the thing is, so which is why we always do the recording national status class first, so that you can get yourself out of their jurisdiction. Now, a couple things happened within that court hearing as well. He took away their jurisdiction, but she attempted to get it back, right? So if you ever have to go in front of them, learn their tactics. When she asked him to put his phone down, if he would have put his phone down and stopped recording, he just gave her back jurisdiction. Okay.
Mm-hmm.
So if you take away their jurisdiction, do not give it back to them. They will trick you. I promise you. Okay. If you see your judge turn around in the chair 1, 2, or 3 times, they just switch jurisdiction on you as well. They'll do that. Like you'll just see them turn. You're like, what are they doing? Right? They're trying to switch jurisdiction. But you do have the legal right to ask them what language are they speaking in? What laws are they going up under as well? Okay. So
When it comes to asking the language, that's another big one. Because, and here's what you can tell them. If I don't know the language, how can I adequately prepare a defense for myself? And you can ask the judge if what he is trying to tell you, if he refuses to give you any information, is if they're practicing a system of law that's known only to lawyers and judges or members of the bar association. And watch him cringe. Watch how he won't be able to answer that question. If you know the right things to ask, you can back them into a corner, because they have to at least pretend like they're a real court in certain aspects. And so you can back them into a corner, make them perjure themselves.
absolutely. So can you guys see my, Caleb, you see my screen?
Yes, I do.
All righty. So of course, y'all know we're going to get down to the foundation first. Okay. You guys got to know what is backing everything and what it is that you're doing. And then I will go into all of the remedies that you need to utilize depending on what stage of the court case you're in, and etc. Okay, so are y'all pens and papers ready when it's time to do that part? But we'll go into the history so you'll know what foundation it is that you're standing on, and it is not the Constitution. So your state constitution, though, if you guys were smart, I will pull my state constitution. I know for a fact in North Carolina, because I read it, because I needed to use it for my own self at one point in time. It tells you that if you don't like their rules, you don't have to abide by them. It tells you that you are considered an American national. It's their first line in their constitution. Say that you are American national on their line, on their soil. So if you really know what that means, you know how to utilize it to your defense. So of course, we are doing the Freedom Edition, the court play. And you can go ahead, Caleb.
Okay, so in order to understand why we're able to administer these remedies, you have to understand what the court system is supposed to be versus what they actually gave us to work with. Because let me tell you, these people are wicked. So, and of course, as with everything else, look up everything that I'm saying, we're saying, and you can do fact checks on it because I'm giving you their words. So, under Article 3, Section 2 of the Constitution, the judicial power of the United States shall extend to all cases in law and equity, to all cases of admiralty and maritime jurisdiction. So this is three different jurisdictions outlined for the judiciary to equity, its contracts, and admiralty maritime is the law of the sea. More specifically, under the Seventh Amendment, it'll tell you no fact tried by a jury shall be otherwise re-examined in any court of the United States other than according to the rules of common law. If you've been with us for this long, then you should at least have a basic understanding of the Constitution and the things I'm about to go over. One being the Supremacy Clause. The Supremacy Clause states that the Constitution is, of course, the supreme law of the land, and every single judge is bound to it. There can be no greater authority than the Constitution. And under the Seventh Amendment, it specifically tells you that no case shall be tried other than by the rules of common law. Common law is the proper jurisdiction under which all cases in the United States are to be heard. And if you don't know what common law is judge-made law based off of judicial decisions. So, for example, if the judge in New York, like happened like 2 or 3 years ago, where he ruled that a gun control statute was unconstitutional, that sets what is known as a legal precedent. If you were in school and you remember the Dred Scott decision, that set a precedent in the Supreme Court. When they overturned Roe versus Wade, that set a precedent, right? It's such a big deal because those rulings act as laws in of themselves. So when judges make a ruling on certain things, that is the law. That is why we have plenty of cases, even up to the Supreme Court, stating that something like a driver's license is unconstitutional. Many judges have ruled on that same thing. So this is your case law. Case law, points and authorities, what you use to prove what you're saying, because it's not evidence unless it's evidence to the judge, meaning that you have to be able to show him this is where it was decided and this is why I'm acting in this position. And then if you could go to the next slide. Now, as we all know, the United States filed Chapter 11 in 1933. They went bankrupt. They lost their sovereignty as a government. And with that, they lost their authority to hear lawful cases in the proper venue of common law because they were no longer a government. They reorganized themselves and started delegating powers all over the place, but they were no longer a lawful agency at this point. And you'll always hear people talking about Erie Railroad versus Tompkins in 1938 because they say this is the decision that overturned common law. It merged law and equity into a single jurisdiction. Before, courts of law and courts of equity were separate, but they merged them together into a single jurisdiction, and that's statutory because statutes, they say, are some semblance of law, and then statutes also govern equity. So it's a bit of trickery that they try to pull, basically merging those two into one. and stopping common law rulings, but that's not entirely what it says. It's more specifically saying that in cases of diversity, they're supposed to use state-based state laws instead of federal regulations. Um, but that's not the most important thing that we need to be getting into, because this one and another Supreme Court decision, Clearfield Trust, is what we're going to be going over shortly. They work together because they made, again, a common law ruling in Clearfield versus United States, and they specifically mentioned why the holding of Erie versus Railroad doesn't apply, and that is going to be important because that is a case that is talking about commercial paper Federal Reserve notes. However, when it comes to further evidence of what I'm talking about here can be found in the Judiciary Act of 1789. So if you've seen that quote that states that there have not been any lawful courts since 1789, this is when the Judiciary Act was passed that created the district courts underneath the authority of Congress and not the Constitution. And that is evidenced by FRC versus General Electric Company, which is a US case. And then if you could go to the next slide, we're going to discuss this case a little bit more. Because in this case, it states courts that are constitutional, as distinguished from legislative courts, can have no jurisdiction other than cases of controversies falling within the classes enumerated in the judiciary article of the Constitution. It cannot give decisions which are merely advisory, nor can it exercise or participate in the exercise of functions which are essentially legislative or administrative. There are lawful courts, and then there are legislative courts. Legislative courts deal with statutes, codes, those type of things. And that is as opposed to a regular lawful court. And one of the main differences is that underneath the Sixth Amendment, you have the right to face your accuser, to be confronted with the witnesses against you. Now that becomes a direct issue when the action that is being brought against you comes from the state of anything, because that state is not alive. That state is not a person. That state cannot testify. That state cannot speak. That state cannot be harmed on account of your actions. And in a common law court, a true court, if you have not harmed anyone, destroyed their property, if there is no victim, there is no crime. So they have us being tried up on all of these absolutely ridiculous victimless crimes, such as speeding. You harm the state by driving fast in your personal vehicle, going about your business. It makes absolutely no sense. And in a country that wasn't backwards, they wouldn't allow that. It wouldn't happen. But this is how they got us. There is literally different courts, and they will not tell you about it. And then on to the next slide. But the example that I like to give with that, how can the judicial branch enforce a legislative statute that was enacted by the administrative branch or the executive branch? That completely says to hell with the separation of powers. Judges rule on matters of law. When they start dealing with statutes, they're becoming policy enforcers and administrators. Yeah, I hope you're starting to see why that's not a thing, or why there's a conflict there. Now, going in with what we were saying, Clearfield Trust versus United States. It says, the United States, as a drawee of commercial paper, stands in no different light than any other drawee. And also, the United States does business on business terms. It is not exempted from the general rules governing the rights and duties of drawees by the largeness of its duties, of its dealings, and its having to employ agents. And if you don't understand what that means, that is that quote where you see governments descend to the level of a mere private corporation and take on the rights and duties of a mere private citizen where commercial paper, Federal Reserve notes, checks, etc., is involved. This is further supported by Cook versus United States. When you're looking at case law, it will often cite other case law to help explain why it's saying what it's saying. And this was an actual citation from Clearfield Trust versus United States, which says that when the United States become parties to commercial paper, they incur all the responsibilities of private persons under the same circumstances. And that's also can be found in US versus Bank of Metropolis and the Floyd acceptances. All of those cases are evidence that you can use to back up the fact that the United States is acting as a federal corporation because they're trying to collect a debt from you. Anytime you have court, there's court fees, court costs, and anytime the United States is a party to commercial paper, they are acting in the same role as a corporation and are bound by the same rules. Next slide, please. So, the Clearfield Trust doctrine that I was saying, you all have seen this, but now I'm going to break it down for you in context. 28 United States Code 3002 15A, B, and C, which states that the United States is a federal corporation. However, under 28 United States Code 3001, which is the applicability of that chapter, it tells you that that chapter, except as provided under subsection B, provides exclusive civil procedures for the United States to recover a judgment or a debt, to obtain before a judgment on a claim for a debt, remedy in connection with such claim. And then, of course, judgment means a judgment, order, or decree entered in favor of the United States in a court and arising from a civil or criminal proceeding regarding a debt. So anytime you are in court, civil or criminal, there is a debt involved and you are being charged. And anytime the United States is involved in litigation, they are acting as a federal corporation. And then could you go to the next slide? It's straight up, that is the meaning of 28 United States Code 3002 and 3001. That is litigation of the United States. The federal rules of civil procedure are under Title 28 of the United States Code. So they cannot play the game trying to pretend like it doesn't apply to them, because whether civil or criminal, when they're trying to enforce any judgment against you and any ruling that they get, it is the judgment order. They cannot enforce that because it means a federal corporation. Subsection B, an agency, department, commission, board, or other entity of the United States, that is your state and state agencies. And then an instrumentality of the United States are your letter agencies, IRS, CIA, stuff like that. Those that have a government contract, subcorporations of the federal corporation, which is the United States, and why every single company that is supposedly government has an EIN. And then moving on to the next one. So now that we have an understanding and then of the fact that the United States is a federal corporation, the other important things to keep in mind are this: corporations cannot interact with natural persons, only other corporations. Penhallow versus Doan's Administrators, Penhallow versus Doan's Administrators was summarized as this: inasmuch as every government is an artificial entity and a creation of the mind, their manifestation in legal sense is the same, and they cannot deal with natural persons. That's an abridged version of it. But Penhallow versus Doan's Administrators is the case. Your straw man was created as a means for you to interact with the commercial world as an agent for that corporation. This is why you when you're signing contracts, anything like that, it's in your all caps name, because this is the only way that corporations can deal with other corporations. The 14th Amendment made all persons, including corporations, people. It gave them rights under the law. They were now able to exercise certain authorities. And this is why natural persons versus artificial persons, there has to be a clear distinction. And this is also why every single statute is not applicable, because they fail to specify natural persons versus persons. But that is another thing. Anyways, in order for you to have any dealings with a corporation, there must be a contract signed by both parties. It has to be signed by both parties. If it's not, and you're signing it individually, more likely than not, you just gave them some commercial paper if you're the only one who's signing on it.
But that's why they make you sign everything. Like, if y'all notice, before they do anything, sign the ticket, right? They want you to sign the ticket on the side of the road. And when they take you in and you see the magistrate or whatever, guess what they make you do? They make you sign something. And actually what you just signed was the warrant, right? Because they have to get the warrant first. So even if you get pulled over on the side of the road and they take you to jail for something, you know how it take them a minute to process you in. You're like, well, damn, what are you doing? Right? They are getting the warrant to get the signatures. So the signature, that's why they say the judge has to sign off on the warrant. Then they bring you some papers that you ain't read and feel as though that you have to sign. So then that's the signature, and then the cop is being used as the witness. And because the cop is a notary, okay, they ain't gonna tell y'all that all cops are notaries, because now they just witnessed your signature because you just gave it to them. But you can go ahead.
Hey, and that is the perfect segue into what I was saying. Is the way that they trick us is by having us sign contracts, such as a driver's license, passport, social security card, without disclosing what they really are. If we refuse to contract, they have no authority. So if you refuse to sign the ticket when you get pulled over, the cop has two options: to either leave you alone or harass you further. If they harass you and they take you into jail because you didn't sign it, and you still don't sign anything that they give you up there, you refuse to sign it, at that point, they will have to let you go. And when they do, you can straight up sue them. That is an easy bag. But if you sat there and did not sign anything and refused to do so, the cop would be the one who always gets in trouble on the other side of that situation. And the next slide. But that was just a beautiful segue. Contracts are how they get us. Your driver's license is a contract with the state, whereby you agree that you'll follow all of their rules and regulations, such as going the speed limits.
Right. That is the last one, number 8. Now that you sent me another one, it was only 8. So y'all got the foundation. You know what laws that you can use in the process of it. But y'all want to know how to get out of this. Right? I want y'all to think about it like this. For the most part, everything starts with a what? A traffic stop. Think about it. They found drugs in the car, they found a gun in the car, you got a suspended license, whatever. But for the most part, it all starts with a traffic stop. So the importance of us telling you to do your FOIA and getting that on the record, right? You stop their jurisdiction there, okay? Because everything starts with a traffic stop. The regular 12, okay, do not go by the Constitution. They said they'll uphold the Constitution, but which one? Have you ever read your state one? You might want to go read it, okay? But if you remove their jurisdiction, where if they do pull you, there's nothing they can do, you're going to stop them from pulling you out your car, taking you to jail, being combative. Oh, I'm a traveler. Oh, I'm a this. No. That was the importance of getting your passport updated, okay? Because when your passport is updated with the FOIA, it now takes you out of their system, where when they attempt to run your name, they cannot access the system. And if they can't access the system, they can't print you a ticket, right? You have to look at it that 12 is the security guards for the DMV. Just as simple as that. So when you're saying that you're not up under their jurisdiction and you're handing them a state ID, oh, you absolutely are up under their jurisdiction because you signed up with the state. I want y'all to really think about this, right? You signed up with the state as an employee. The police is the security for the DMV. You registered your car with the state, right? So that car is not yours, it's a state vehicle now. And state vehicles, if you go look it up, have to be up to code because they're state. No outlights, no whatever their rules is. Y'all know what it is because you're in a state vehicle. But at the moment that you correct yourself in the system, you now just took away their jurisdiction. We have all seen people all the time on these videos, I'm traveling. Why say it and you can prove it? This is why we tell you to get the passport book and the card. The passport card is for travel on the land and the sea. So whatever you happen to, without you having to open your mouth, you hand them your passport card and they know that you're traveling. If you hand them a passport card, they're going to ask you every which way from Sunday, please give me an ID. Please give me a driver's license. If you've had this issue, you know it. Because guess what? You have to give them, once again, jurisdiction. They are under the state, which is up under a government contract, okay? And that contract comes from the IRS. Every last courthouse, every last police station are subsidiary companies up under the state, which is up under the IRS. Their checks actually come from the IRS. So at the point that you know that they're a private company, now you deal with them as a private company, okay? One, get yourself out of their system. This is why we taught the recording national status, do not detain before we taught anything. Even though the systems are different, they play a role to a certain level, okay? So you rescind your driver's license. Every state, if you Google it, you can put your state name in and say rescind driver's license. Every state has their own form for you to fill out, and you can go turn your driver's license in. You're traveling. The passport card is for travel on land and sea. If they're using maritime law, that's the sea. If we're on land, that's the land, right? So once you get out of your system that way, you just remove their jurisdiction. Okay. One thing that we all learned in school was that all government entities have what? Tax exemption, correct? Isn't that what we all learned?
Yep.
Okay. So if they have tax exemption, you can make them prove it. And I'm going to show you how. Because if they are truly a government entity, as they tell you that they are, it's all about calling these people bluff. They say they government, prove it. I just told y'all they work for the IRS, right? Y'all see that form? 4506T form. If you fill this out for any police station in your state, any courthouse in your state, the DMV, and any of these supposed to be government entities as they're calling themselves, that means that they will be exempt from taxes. Prove it. Fill out this 4506T form. Put their information in there. We already told you they got EIN numbers. Pull them up. Each one of y'all police stations, each one of y'all courts, DMV, social service, child support, they all government, right? Prove it with this form. I can promise you, as sure as my name is Timika and not Tamika, the IRS is going to send you back a paper saying, we have not ever heard of this company. Signed, sealed, and approved. So you just took away the fact that they're saying that they're a government agency at this point. This form is very simple to fill out. It's asking you basic stuff. If it's Kent County Courthouse, you put Kent County Courthouse up here. their EIN number, whatever their address is, and you ask them to send you a transcript, and they're going to send you a sealed document saying that they are not government. So that's your first piece of evidence to be able to get out of your cases. Okay. Definitely, if you've done the FOIA, you are going to want to go put that on file. Even though your governor's office got it, you're going to want to go put it on file, because that removes now the sheriff's jurisdiction. And we all know that these private jails are ran up under what? The sheriff's department. So if you can remove the sheriff's jurisdiction, they'll be like, the sheriff will be right back, because there is no sheriff in there. And if there's no sheriff in there, you're not up under their jurisdiction, and that can't register. Okay. So the first thing that you will always do is this 4506T. Now, you can look up the 4506T under public records, okay? And it will come back the same. You will get it immediately. But you want it to be a certified copy from the IRS. You can go on IRS.com and put in 4506T search. You can put in a name. It will come up, and you can print it out. But you want to get a certified copy from them to prove that you just didn't make that piece of paper up, okay? You got something you want to say about this before I move on?
Were you going to segue into the 211?
I don't know. Because
that would go hand in hand with if they couldn't find the company, and then if you did that as well. But if not, then I don't got nothing else to say.
Well, it absolutely will. Well, you can touch on it. But how can I say this? Beware. Okay. Beware that if you attempt to mess with this form 211, and I will pull it up. Let me show y'all this form I'm talking about. You better know what you're doing. Do not open up a can with this form if you don't know what you're doing. So this is the form. And honestly, before you go, Caleb, you know why they always want you to get an attorney? Please get an attorney, even if you fire them, because they need that additional signature, okay? They need the signature. Because what happens is your attorney, the one you hired or court appointed, filled out this form 211 on you. Okay. Now, y'all remember in the beginning, I told you that the course is ran by the IRS. Every court case that's in there is actually a tax case. It's a tax case. On the public side, it'll say that you were carrying a concealed weapon. On the private side, it's going to say you didn't pay the taxes on the security on the weapon, right? So when they claim that they went and got an indictment against you, it's all about taxes because they work for the IRS. And because of that, your attorney does what's called a whistleblower. This is the whistleblower form, and they need you to get an attorney because y'all see what this says here. What is your relationship, current and former, to the alleged non-compliant taxpayer? Here is the big attorney button. They are going to click this button on you. They're going to send it in, and now you're being actually charged with taxes, which is why they always get an indictment, because they didn't go in there and say that you didn't pay, that you had a gun on you. They're going to say that you had a gun and you didn't pay the taxes on it, right? Because we do have the right to bear arms, regardless of whatever state that we're in. So that's my take on that, but you can tell them about this form.
Well, I was just going to say that you can put two and two together and see that if you do a 4506T and there is no proof that they are a government agency, they're obviously not paying their taxes. And so that's all I want to say about that. That is all I want to say. But like she said, if you don't understand what you're doing, I wouldn't recommend going this route. I wouldn't, because yeah, you'll get yourself into something that I'm not sure that you're ready to back up.
Yeah, because you have to know how to execute it properly. But the option is there. And you will fill that form out on your attorney. You'll fill it out on the judge. Because ultimately, because this is all about taxes and securities, okay? It's all about taxes and securities. You can fill this form out because everyone in the courthouse has a fiduciary financial interest into your case now, which makes whatever ruling that they give, it makes it illegal because you can prove that they now have a financial interest into your case because they all get paid. Okay. Now they get paid a hourly wage or however they get paid from the IRS. That's their check. But you can pull this information because it's free information where you can see how much a judge got paid. You like, well, they didn't got paid $400,000. The way that they put it on the books, it'll say like luncheon fund or et cetera. It's not added in their regular paycheck. So everybody from the clerk on down has a financial interest into your case, which automatically make it biased, and they're really not supposed to charge you. Okay.
It's a conflict.
Absolutely, the conflict of interest.
And so what we're trying to do is get to the realm of being able to prove that conflict. And, you know, pulling that 4506T will show that they're not even a government agency. And so they have really no business doing anything like that. And that other form, that can do some serious damage both ways.
Okay. So if you know what the meaning of warrant is, anybody know the meaning of warrant? If you know the meaning of warrant, raise your hand. Mr. Cox.
What's up, Tamika?
Hello there.
How you doing?
I'm amazing. How about you?
I'm well, thank you. I wasn't raised. I was just like chilling. I wasn't. I got my hand raised. I got a question, but I wasn't raising it to answer the warrant question.
Do you know what a warrant is?
Yeah, I'm familiar with
What
it.
is it?
That's what they use when they want to come and arrest you, or come into your house or whatever to arrest you. Am I right?
Okay. I mean, yeah, that's what they use it for. Yeah, they use it for that, but that's not what the actual meaning of a warrant is. Anybody else? Sounds alike. What's a warrant? And it's something because I put this on my page. Tell you how much attention y'all don't pay. I literally put what a warrant meant on my page. Sounds
With the
alike. You
whole
know what a warrant
definition.
is? William Parker. What's a warrant? You can unmute.
Yeah, you can hear me?
Yeah, I can hear you.
Yeah, it's like a draft or either an order, if I'm
That
not
is true, but
mistaken.
a draft or an order of what?
It's like a draft or order. I know this stuff because I'm a certified paralegal, but I know looking at the definition, it typically says that it's a draft or order. Now, as far as alluding to what the order is about, I didn't get into the details of that.
Okay. Pick somebody else for me. Nephew, can you pick somebody else for me?
Yeah, sorry, my
No, you
mic was
good.
muted. I said, yeah. I'm looking right now. Sons of Light.
Yeah.
I think one more person and we'll see if they can get it.
Juan Medina.
Keisha Johnson. Oh, you got it.
A warrant is a paycheck,
Oh,
and it goes through the comp controller. It's an obligation, and they use it. They always write out a warrant, in order to bring us in,
You got the AC on us? Oh, no.
and they
Fine.
cash
Alright.
it in.
So let's talk
Gotta
about
be
what
on
that is
75.
part of it. That's definitely part of it. But let me tell y'all what a warrant is. Okay. So they told us that the warrant is for them to come pick us up. They got to sign by the judge, right? So one of the meanings of a warrant is a writing that authorizes a person to pay or deliver to another, and the other to receive money or other consideration, right? Then, this is what I wanted to see somebody to tell me, and it's on my page. A warrant is an instrument issued by a corporation given to the holder the right to purchase the stock of the corporation at a stated price, either prior to a stipulated date or any future time. That is what a warrant is. It is an instrument. If you've been with me for a minute, you know what an instrument is. It's a bond. So that's why the first thing that they have to do is get the warrant. They need you to sign the warrant because you just purchased stock in that corporation. You see, they said it, right? So your signature actually purchased the stock of the corporation at a stated price, either prior to the stipulated date or any future date, right? So all warrants in all cases are turned into municipal bonds. That is the type of bond it is, a municipal bond. And only special type of brokerage services can even deal with a municipal bond. While you only need a 7 and a 24 to deal with like your commercial contracts and etc. When it comes to municipal bonds, they have to have every certification it is. I think it's like 9, Series 63, Series 62, Series 7, and etc. Right? So your case is now just turned into a municipal bond because we just told you that all of them have a financial interest into your case, because everyone who signs off on your case now gets their what? Their percentage, because the course is a brokerage firm. It's all about taxes. So your bond is turned over. The warrant is turned over as a bond, and they are traded through the CRIS system, the Criminal Risk Investment System. Look it up. And if you've ever had a case and really want to know what your case is worth, you have 2 ways to do this. You can do a FOIA, Freedom of Information Request, through the CRIS system. It is literally on the bottom of their page, FOIA, with your case number, and have them send it to you. Or you can also go into a brokerage firm. Do not tell them it's a court bond. This is my court case number, run it. They're going to look at you crazy. Remember, it's all about speaking their language. You can go into any brokerage firm, hopefully you have an account and it's a relationship, and say, hey, can you run a municipal bond for me? Municipal bond for me. And you will give them your court case number.
Thank you.
Then they will print you out a sheet that shows you all of the trades that they've had on your case. You guys understand that?
That freedom of information that you do for your case number is the most powerful tool that you will ever get, because this proves that the court, again, has that financial interest in your case and that they're making money. That they're making money off of it, and that they're holding you as surety for these bonds that they drafted up. And as she said, a warrant is a financial instrument. I really hope y'all are catching this. But again, this goes on further to prove that they have no authority to prosecute the case. It's a conflict of interest. So you can get your cases dismissed under fraud upon the court. So yes, court registry investment system, freedom of information for all bonds and financial instruments, and you put your court case number in there, and they will send it to you. That is enough to get rid of any court case. Any court case. I saw one of y'all in there saying, "Oh, you think that this would work on a murder charge?" Actually, yes. That's not that I condone that, but the courts are fraud. It doesn't matter what the charge is; it can get dismissed. That's how powerful that document is, and I want y'all to really let that soak in. You could gun somebody down in 4K video on a Wednesday, and they still couldn't prosecute you and take you to jail. You know why? Because you wouldn't sign anything. So just let that soak in. Just let that soak in.
You got a question, Eddie Styles? There you go. Okay. So now that y'all know exactly what a warrant is, you know that it is a case. So when you're trying to get out of these cases, you need to treat it exactly for what it is. Okay. So if you are actively in a court case now, if you have an attorney, you absolutely positively have to fire him. There's no way around it. He has to be fired because the law says that absent an attorney, look at the wording, and this is also on my page, absent an attorney, you cannot be jailed.
Nope. Without a knowing and intelligent waiver. That is what your attorney fills out on your behalf.
Sure does.
It's not good.
It sure isn't.
Because again, it takes 3 signatures to put someone into jail. The judge, the prosecutor, or anyone acting as that witness, and yourself. Anyone who is in jail, it's because they signed themselves into being jailed. Let that sink in. That's a little messed up. When you understand that everybody who's in jail consented to being in jail because they signed papers, you start looking at things a little differently.
You absolutely do. And it's also 10 cents. So if you know that a warrant is a financial document, you know that any commercial paper, you have to pay the taxes on the case, okay? So if you're dealing with the active case, if I was you, I would get a PN right now. You are dealing with the active case. The first thing that you will want to do is go get a certified copy, or you can call it a true bill of the entire case. That right there will let you know everything that is within your court case. You know how some people go down and they say, I filed this in there, and the judge didn't even pay attention to it. It's because they didn't put it in the file. Yes, they did stamp it and made you think that it was there. But when you go and get a true bill copy of your case, you will now see that that form is not, any of the documents that you filed will not be in there at all. They won't be there. So the first step is to go down and get a certified copy, true bill of your case. What that will show is, yes, they're going to charge you for it. So before y'all ask, it depends on your courthouse. It will depend on what their fees are, and how big your case is will determine how much it's going to cost you. But go and get a true bill copy of the case. Once you have a true bill copy of the case, you are going to go to the post office and you're going to get 10-cent postal stamps. Okay. So let me show y'all why you're going to get 10-cent postal stamps. This is the wonderful postal treaty, the one that I tell all you guys to go find. So if I was you, I would snapshot a picture. It's the second edition, United States Postal Stamp Duty, the Act of Congress of 1860. Okay. You want to get this. So I tell you that you have to put a 10-cent stamp. And I always tell you that I'm going to show you where they said that is a 10-cent stamp. For you guys that's trying to figure out how much stamps to put on your mortgage, you see this? If you scroll down, it tells you the stamp duty, depending on what it is. And it tells you the amount on the side right here. This is the one that you want. All of them ones that's floating around Scrib and all of that. No, what you want to do is, as long as this stamp duty act was not thrown out, you want to go get the oldest stuff of their wording that you can find, because that's ultimately what they're ruling up under. All of these new postal things that you see that people have made up, that's on the new paperwork to deceive us. That is not the actual amounts. So please go get this. If you Google it, it should be there. I don't know, maybe
if you Google stamp duties 1863, this will come up. I downloaded it. It shouldn't take you more than 30 seconds on Google to find it. Z Library. There's plenty of online libraries that will have it. And it does straight up tell you what to do on any court document and how much of a stamp that you are supposed to affix to said document. So when we're talking about the UPU treaty and stamp duties, that's this document. Sorry, go ahead.
So if you go down to page 15, it tells you right here, legal documents are writ or other process by which any suit is commenced in any court of record, either law or equity, 50 cents. So a writ of eviction. If your landlord is suing you, it is 50 cents. They said it, not me. Y'all see this? A writ, because when they evict you, what does it say? Writ of possession, right? When they are filing for eviction on you, and it's the original process of that first set of paperwork that they give you, and depending on what state you in, they say you got 7 to 10 days to respond. You take that paper that was served to you and you throw 50 cents worth of stamps on there, and you take it and refile it back into the case. Okay. Now y'all heard me just say they don't like to put the stuff in the file. This is how you guarantee it go into the file. You go down there and you re-put it back into the file. And then when they ask you, can I help you with anything else? Say yes. Now give me another certified copy of my case. So what you just did is you just locked the court clerk in, right? You locked her in. Now she can't say that you did not pay your taxes on the case. You just tied their hands because you paid the 50 cents, and they're not able to trade your case because you paid the taxes on it. Okay. So the 50 cents is only for writs, writ of eviction, whatever writ that it could be, you will put 50 cents on there. Okay. Now, any other case. Y'all see, they even talk about playing cards. Y'all should look up what playing cards actually is, and it ain't no spades either. Ain't no spades either. No. Oh, these late people trying to come here. I'm not here. So, on page 20. Okay. If you download this on page 20, so remember I said get the clerk of court to certify it. When the clerk of court certifies a paper to be a copy by watermarking the same copy and signing his name thereto, it will be necessary to affix a 10-cent stamp. This is why you get a true bill copy of your case. The clerk is going to put a seal on it. She's going to physically handwrite her signature, and she will only write it in blue. So that should tell y'all something. She's going to write it on every page. Do not let them trick you and say, oh, do you just want your deposition? Oh, do you just want your arrest record? No. I need a full true bill copy of the entire case. And then at that point, every piece of paper she has to stamp and sign. And on every sheet, if you got 50 sheets in there, all 50 sheets need a 10-cent stamp affixed to the bottom right-hand corner on the back. Okay. Now don't forget that if it's a writ, it's 50 cents, but at the point that the clerk certifies that writ, now you have to put a 10-cent stamp on it. Okay. So y'all get this. Maybe I'll put it up so y'all can get it because I know people still. Oh, bonds. Let me show y'all bonds. It just bonds. You know how they give you a bond in court for you to bond yourself out? It's 50 cents. You put a 50 cent on the actual bond paper because the bond is an actual promissory note. You put 50 cents on that one as well. So once you get the certified copy, you put all of the stamps on there. You will take that. You will take a copy of your FOIA paper and you will file it back into the case. Once it's filed, get another certified copy. That way you make sure that it stays in the file and that they don't throw it away. And that's for any case. If you can go a step further because they are really not asking for you. They're asking for the person on your birth certificate. Okay, that's what they're asking for. Because anybody who's been, and I had a student like a year or so ago, he did prison time. And when he went and got a certified copy of his case, do you know what's in the back of it? A copy of his birth certificate, and they had stamped it. So you too, because that's what they want to get out of a case, you could take a copy of your birth certificate, put paid to the order of whatever state it is, and also add that into your file. Any questions? Any questions? You can find somebody to ask a question about that.
All right, let's see. I'm about to lower everybody's hands because the fact that any of your hands up was disrespectful. And the first person who I see, Jake Belcourt. And if y'all ask any other question about this, then what we just asked about, it's going to be an issue for me.
Hey, how y'all doing? I have a case. I was on probation for a year. Is there any way to go back and do this to get that off of my record?
Absolutely. So in a case that you've already had probation or etc., you will have to rescind your plea. Okay, you have to drop a motion, rescind your plea, based off of Rule Civil 60, which is fraud upon the court. That's ultimately the same thing that Caleb did.
Okay.
That's exactly what I did. You have to put in a motion to withdraw your plea with a notice of motion to set a date. And then what you can do is the judge will have, depending on if it's a state or federal court on the website, the judge will have times that he's available to hear certain types of hearings. And so depending on what type of matter yours is, you'll find the category, see what dates he does it, and then you can set a hearing date to go in and get that addressed.
Okay, and then in the meantime, do I get the certified copy of the case and stamp it and all that?
You're gonna
Yes.
absolutely need to do that. You still have to do all of
100%.
that because you're doing fraud against the court, right? So you're definitely gonna need to do that because there's already an active plea in there, along with your FOIA. I will also, because you've already pleaded out to it, I will also do the 4506T form because now you have to prove that they had no legal right to even try you because that's what you're doing. Okay, guys, never try to go in there and beat the charges. It will never work. You can't beat their charges. But what you can do is prove to them that they have no right to have you there. Okay. You start with never having an attorney. Okay. In your case, because it was already a closed case, because you have probation for it, you will also file a Q warranto.
What's that?
A Q warranto. QUO warranto. You can also, within your motion itself, ask them, did they get permission from the Secretary of State to try you? Everyone that's in court, there has to be permission granted by the Secretary of State because the sheriffs actually took an oath at the Secretary of State's office. The Secretary of State in your state is the head office, just like the Department of State is over everything. That's why you get your FOIA for them. For your particular state, your Secretary of State is the office that they actually took their oath in, and they took a secret oath. All sheriffs took a secret oath inside of the Secretary of State office. Okay. In a case that you've already you've pleaded and now you're going to rescind that plea, once you get a certified copy of that case, I will definitely get it authenticated. I will definitely get it authenticated. And let me show you something.
I'd like to add too, I did my FOIA for the citizen search, and they came back with that stuff that you guys were talking about, I think in the TDA class where, 100 years or older or whatever. And all I did, what's that?
We gave you guys a solution for that. In that same class, we told you guys exactly what to do.
Yeah, so, but I was just going to add, what I did is I took the words that they had sent back to Caleb on the ebook, and I told them exactly if nothing came back responsive to this search, I need you to put that in the report. And then they sent it back again, and it was exactly what Caleb got.
And thank you for saying that, sir. I really appreciate that because that is exactly what we said to do in that last video, was to tell them to run it anyways and give them that exact sentence, the person-centric identity search. So for everyone who is having trouble with that, you can hear first that it can be done. You have to tell them to do their job. They didn't say that the records weren't there. They said it's generally not under the purview of the UCIS. Tell them to run it anyway. Thank you, sir. That's all I got to say.
Yeah. And so if you had that issue, go back to that video and use the language that was given.
If you have the ebook, I have a picture of the snapshot so you can see exactly what the wording is. I have posted on my page. If you look, I have a folder a playlist called Status Correction. In there, you'll get another example of what it says on there. You can tell them to run the search that way. But yeah, so just to let people know it can still be done.
Yeah, it pissed me off. It's like, no, you're gonna give it to me.
Yep, and that's what they do. They tried to deter you, but you kept going.
Yes, sir. All right, thank you guys.
You're welcome. So cure warranto, this is what it is. It's by what warrant? Cure warranto means by what warrant, right? So remember, I just told you guys that the warrant is a security. So now you're going to ask them by what warrant are they bringing you in there? And it falls back under, as we said earlier, as Caleb said in the beginning, it falls up under common law remedy. Let me tell you something. You do a cure warranto, it's gonna, in its tracks, okay? In its tracks. But the way that you do the filing of the cure warranto is that you are now doing a countersuit against the court. So they sent you a suit, right? Because that's all every case is. I don't care what the charge is. So y'all, we ain't talking about charges. It don't matter what charge it is, okay? So they give you 10 days to respond for a reason. But you can also do a countersuit. So when you're filing a cure warranto, okay, which means a writ of cure warranto is a common law remedy, which is used to challenge a person's right to hold a public or corporate office, okay? So why are you challenging their office? A state may also use a cure warranto action to revoke a corporation's charter. Do you guys know that all the courts actually run off of a state charter? Cool. You might want to get it. Because one shows that they don't have any authorization. So get you, because they are corporations, they're not government. So they have a charter. You have a state charter. You have a city charter. That's public information. It tells you what capacity they can work in. Okay.
Mm-hmm.
So when you bring a petition of writ of warranto, individual members of the public have standing as citizens and taxpayers. In a case in Alabama, it utilized the test whether a person may lawfully hold office, and the purpose of the writ of cure warranto is ascertain whether office holder is constitutionally and legally authorized to perform any act. So how y'all going there talking about, oh, your jurisdiction, oh, you don't have no rights over the structure, file a cure warranto. And when you file it, you are the plaintiff, okay? Because it's a countersuit. So say they're suing you, or you got a warrant, you in a criminal case or whatever. You see, it always says the state of North Carolina versus Al Brown, right? You're gonna flip it. You're gonna flip it, and you are going to be the plaintiff. But in the defendant box, this is how you get the entire court not to mess with you. You put the court district's name, you put whatever judge that you have, and you say all judges, so that way they won't try to put a new judge on your case, because you know they're good for that. Once you beat one of them, they don't want to give up, so they're gonna get another judge, stop them in their tracks. Okay, put the state on there, since they say the state of is the one that's criminally charging you, right? So as the plaintiff, you'll list all of them, the court clerk, and you can put Kent County Court clerks with an S, judges, plus the original judge that you have, their name will go on there. Whoever the prosecuting attorney, their name will go on there. And then you go file a suit against them. So now you are demanding that they show you the legal right to have you there. FYI. And I want anybody to call me on my bluff. Call your licensing regulation department for your state. It's public information, right? And ask them to provide you a law license.
I would probably
any
try to
judge
assassinate
or
her.
any
Like, oh, she going in.
Excuse me, sir. Could you mute yourself?
Who is that? How did they even unmute this?
He answered a question earlier or asked a question, but please,
Okay.
and
Oh, my
anyone who
bad.
unmuted, please mute yourself back because you just were speaking over her for the good part of a minute there.
My bad. That's me. Hang
Yes,
on.
it is. Please
Thank
mute
you.
yourself.
How do? Hold on. All right.
Okay.
I do appreciate the praise. She was going in, but you just make sure you're muted.
So call your licensing regulation department in your state and tell them to provide you with a copy. You can put any lawyer, go on your yellow pages or your Google and find any lawyer in your state or any judge and ask them for their law license. They're going to tell you there is no such thing. But wait a minute, didn't the law say that in order for you to practice, you have to have a law license? There's no such. They have bar cards. Bar cards are not licenses. You can use that to your advantage. Say you're actively in court and you didn't have time to turn in no paperwork. I'm gonna give y'all 2 for surefire ways to stop that court case in its tracks. Y'all ready? As soon as the prosecutor began to speak, say objection. They're gonna ask you, well, what are you objecting for? You first question, is the prosecutor testifying? The prosecutor is going to say yes. It's about putting these people back against the wall, y'all. So the prosecutor is going to say yes, they're testifying because they know on the night of 111, you did this. So then you say to them, when the prosecutor is testifying, I need them to swear in. How many of y'all ever seen a prosecutor swear in? No. Have you ever seen them swear in?
It's never happened.
Never. But if they're
And
testifying to the facts, you had to swear in, right? They made you put your hand on the Bible, say, I swear to tell the truth, the whole truth. So help me God. You can use that for you too, because you swore on what you think is a holy Bible. So if you know that Bible, you can use the words of that Bible to save you. And I'll tell you what it is shortly. But yes, you can make them swear in, they never will. Because they're testifying, stating that they have fact. How do you have fact that you see me run a red light on Washington Street and I don't even know you? But that's what they're testifying as. That's the first question. Okay. Then use the law license question and call their bluff. And they can be talking and you say, objection, be real humble. Say, objection, Your Honor. Is the prosecutor practicing law? They're going to say, yeah. And you say, well, I need this case to be adjourned until Mr. Prosecutor, and no disrespect, Your Honor, until I see your law license. They ain't got one.
no, they do not. Auntie, could I interject for just a second?
Absolutely.
So, Square versus Board of Examiners, New Mexico Supreme Court case straight up ruled that there is no license to practice law. So when you're using that, that's something that you can use to use. But in response to what she was saying about, is the prosecutor a witness? I'm going to give you a couple cases that you should write down to help support this. Trinzi versus Palagero. Trinzi versus Palagero. This is 229 F 647. Statements of counsel in brief or in argument are not facts before the court and are therefore insufficient for a motion to dismiss or for a summary judgment. Another one that I would like to use is Porter versus Porter. The practice of an attorney filing an affidavit on behalf of his client asserting that the status of that client is not approved inasmuch as the affidavit has become hearsay, but it places the attorney in the position of a witness, thus compromising his role as an advocate. An attorney, when they are practicing, can only be they can be an attorney or they can be a witness. They can't be both. And statements of counsel are not facts. And there's several case laws supporting that. But yeah, I just wanted to interject with that so that you can have that. And then again, Trinzi versus Palagero, an attorney for the plaintiff, again, cannot admit evidence into the court. He is either an attorney or a witness. So that is just a little bit to help expound your understanding on that. No license to practice law, and if they are trying to practice, they cannot be an attorney or a witness. Anything that they say is hearsay. They do not have any firsthand personal knowledge of the facts, and therefore they cannot make the facts. And if you were to ask a prosecutor to swear in, I guarantee you they'd walk out of that courtroom. They don't want nothing to do with you.
Okay. So, okay. So another thing, if you are getting a certified copy of your case, depending on what type of case it is, and you want just a little bit extra backup, or if you're working to get an inmate that is currently locked up out of jail, you can do that. Okay, they will need to send you a power of attorney for legal, and then you can step in for them to assist them. I even had this was like 2 years ago, and I'll try to find a review because I still have it, where a lady got her son out. So remember how I told you guys you could take your birth certificate and you could put pay to the order of the courts on the birth certificate, or you can put the Department of Revenue Service, because the Department of Revenue for your state is the parent company per se, right? So when you guys are looking for the trustee and an indenture trustee for anything that is state related, you will find it up under their parent company, which is the Department of Revenue for your state. Okay, if you go on to Duns and Bradstreet and put the Department of Revenue for Las Vegas on there, when it says subsidiary companies, you're going to see the police, the DMV, DHS, child support. You're going to see all of that on there. Okay, so their main company, even your state lights, water, gas, etc., if it's ran by the state, your parent company is the Department of Revenue for your state. Okay. Depending on how much time you have left in your case, if you have enough time to do this, once you get a certified copy of your case, you are going to go get it apostilled, authenticated. Okay. Let me tell you where they say you can do this at. Because now you want to make sure that them signatures and everybody is actually lawfully can do what it is that they're doing. So you got the clerk seal on there. You will get that seal apostilled on your state level at your state DMV, your Secretary of State. And then at that point, you can also, you want your CUSIP number, send it on a federal level, just like you do your birth certificate. They tell you this. Now, I am on the Department of State website. Y'all see this? I'm on when I tell us, they tell us everything. So I'm on authentication certificate requirements. Here are examples: birth certificate, marriage license. So when y'all asking about your marriage license, which is a certificate that you can go trade, go get it authenticated. So it'll say it has the full faith and credit on there. Okay. And yes, you're able to sell that. Your death certificate, divorce decree, probate wills, and any judgment. You can get it authenticated. But then it says, under other documents, affidavits. If you do an affidavit and you want it to stick, go get it authenticated. They have to pay attention to it. Agreement. Your article of incorporation, if you are a business. Bylaws, because when you trying to get to the other side of the bank, you have to create bylaws. You want them to stick, get it authenticated, because you had to get a notary to sign off on it. And remember, a notary is higher than a judge, guys. Why do you think every court document has a notary on there? The notary is which actually makes that document now lawful. Okay? So you can get your article of corporation, your bylaws, commercial invoices in it, a copy of your US passport, just the identification page, can be authenticated. Deeds of assignment, we'll go over this in the mortgage class. But once you properly accept that deed and you get that notary, seal it with the authentication. Okay? Diplomas, yes, our diplomas are securities. That's why they want everybody to graduate. If you still got your diploma, look at the paper it's on commercial paper. Get it authenticated and on a federal and state level. The reason for the federal level is because it's gonna give you a CUSIP number at the top. And then you can go use that number to trade it because it's yours. You're older in due course, y'all. Home study, income verification, power of attorney, single status, transcripts, or any other document, but it's for nothing. It literally used to say court cases. It used to be right here. So instead of them now saying court cases, they use it as affidavit. Because everything that is filed into your court case is done, it's saying it's an affidavit, right? So you are able to get that authenticated. So if you have the time, after you get the case certified, you added your stamps, okay? Don't add the stamps on there until after you get it authenticated. I'm telling you that. After it comes back, add the stamp because they may give you an issue. Okay. So you'll find this information up under the Travel Estate. It's actually the exact same. Oh, here it is. So you see where I told you guys, you have to get it certified. It can't be certified by a regular notary. The documents must be certified by the Secretary of State. Okay, so you take the true bill copy to your Secretary of State and you get it authenticated. Once they give it back to you to make sure that they were lawfully able to authenticate it, then you send it on a federal level and it's all court documents. So when you file it back into the case, they know that you know, and the only thing they can do is do the proper thing. Okay. Any questions? What we went over so far? Can you pick a hand for me?
Let's see. Melissa Kelly.
Nephew.
Yeah.
Thank you. We mentioned that we had to have the document apostilled. I've
Melissa
had
Kelly, I can hear you.
Can you hear
Hello?
me now?
I still can't hear you.
Can you hear me? Auntie, we can hear you.
Nelson Hussein, Azan.
Hold on. Give us a second.
Can y'all hear me? Raise y'all hand if y'all can hear me. Your actual hand. Okay, so y'all can hear me, but I can't hear anybody else. Let me change back to my other. Okay, can y'all hear me?
I can hear you. Can you hear me?
Yeah, I Yeah, both of my running because I had the screen on the other one.
I see.
Okay, so I had to change it back. Hold on, y'all. Let me find this. You can call on somebody for a question.
Melissa Kelly again. I'll have you go since you got
Thank you very
interrupted.
much. Can you hear me
Mhm.
now? Fantastic. All right. I had a question because it was mentioned to have the document apostilled before sending it to authentication. And I've actually had stuff sent back on the federal level because they were asking that the Secretary of State in Texas authenticate it before I send it to them for authentication. They couldn't accept the apostille. So
That's
I want to make
correct.
sure I wanted to get it right because we mentioned have it apostilled and then send it to you.
Right. The state is, depending on your state, it may say apostille or it may say authentication, but it's on the state level. So correct. It does have to be done on the state level first, because what the federal level authenticates is just the certified signature. So they're certifying the state certified signature. So it has to be done through the state first, and
Correct.
then it has to go up.
But I have two different choices at the state level, and one of those choices would get sent back if it's not done correctly. I've had
So what
apostille.
choices do you have? So you have apostille and authentications, correct?
Uh-huh.
So you use the authentication.
Okay.
Yeah,
And
I
not
was
apostille.
gonna say,
Okay.
in
Thank
some places it'll be the same, but in most places, authentication versus apostille, they serve two separate functions. So if they were saying they were specifically requiring an authentication and you got it apostilled, that is true.
Yeah.
You would do an authentication and then they would be able to do it that way.
Okay. Thank you so very much.
You're welcome. And Caleb Saunders.
Thank you very much. So I am currently on federal probation. I am on the term of supervised release, where I'm technically eligible for release after 1 year, which would be November 21st, 2023 of this year. Unfortunately, I did get a DUI conviction on the state level, which is not currently in the courts. I did, based off one of your previous videos, try to get a copy of the case, but the court clerk said that they didn't have a true bill of copy because it hasn't been filed, meaning that they had like a year to file. But overall, my first priority is trying to get off of federal probation. So I'm trying to understand what is the process, and also I have a good understanding of the process based off today's course. Thank you. And understanding, do I have to abide by that 1 year minimum, that they say for federal supervised release before I can get off, or can I get off, if I start getting, the right things authenticated, and I already have my 10-cent stamps and my treasury stamp I got from quill.com. But for as far as going by the postal treaty and the stamp duties, can I do things now to get off before the 1 year minimum for supervised release on the federal level?
And when is your 1 year up? November the 1st this year?
November 21st, 2023 will make 1 year I've been out of the feds.
So if it was me, you're almost there, right? I wouldn't ruffle their feathers until I get off. But then to get that taken off of your record, then go back and do all the steps that we told you.
Okay.
Okay. Now, if you still had a year left, I would say go for what you know. Okay. But because you're literally right here at November, okay, because ultimately, once you see the financial interest they've had in your case, you have a certified copy of your case, then you can go back after them then so they can get taken off of your record. Any case, you want to get a certified copy of it because that is a security. Get the true bill, it's a security. And you can deposit that because you're older in due course, the same way you do any other commercial note, because it is a commercial note. It's a municipal bond. Okay.
Okay. Thank you.
And if you want them, you're welcome. And the purpose of you getting it authenticated on both levels is so you can get the QSIP number of the case. And then based off of that QSIP number, you're able to attach, sell that QSIP number. And then now you're getting paid off of that as well. So you right there and just get it removed off. Okay.
Thank you.
You're welcome. Before I
Um,
forget, go ahead. What's the next question?
So would I be also able to collect on any like bid bonds or performance bonds from the federal side? Because my case was a state case and the feds picked it up before, I served the majority of my term. So I was wondering on the state side in the state of California and, on the Fed, BOP side, would I be able to collect any bonds once I, clear up the probation and stuff?
That's how you collect the bonds. By
Okay.
getting a CUSIP number to it.
Number,
And now
okay.
you're the holder in due course because you've already given them permission to utilize it, right?
Mhm.
So, but due to the fact of how they did the bond, you're able to do the bid bond, a performance bond, and et cetera, based off of your case and the CUSIP number that you will get when you get it authenticated. So that can be transferred to you because they're only supposed to get 20% and you're supposed to get what? 80. So
80,
then
yeah.
that's how you're able, correct. So that's how you're able to cash in on it.
Okay. Second to last question, I'm going to make it very quick. Are there any templates and any ebooks that you're going to be providing, like the TDA book for the security instructions letter? Well, for the rescission of security interest?
I don't know. I didn't do it. You have to ask Caleb that question.
Okay. Thank you for that. And my last question is going to be.
That's it. I can't.
Thank you.
It's like answer 3 or 4. Good try though. Good try. I gotta give somebody else a turn to ask a question. That just wouldn't be fair. Let's see. Paul.
Hello, good afternoon. Good afternoon, everyone. Can you hear me?
Yeah.
Hi, so thank you so much for this. I'm in removal proceedings. The date will be October 16th. And I've been trying to get, the who's prosecuting me, like who's bringing the case against me. All I get is, your removal proceedings come, on this certain date. It's not signed by the clerk. There's no name of the judge. There's nothing on that document.
What are they removing you for? What type of removal?
They were saying in 2011 for marriage fraud, which at the time I had a lawyer and I asked them to prove it, and they could not prove it, but they still would not let the case go. And even when I asked
marriage, you said
for
marriage fraud?
Marriage fraud. So we asked to prove the marriage fraud, and they
You
could
was
not
married to more than one woman at a time?
No, no, I was just married, period. So they came and said that they didn't think the marriage is bona fide, and we're asking like, what's the proof of all this? And they could not give any proof, so they could not move ahead. But I expected that my lawyer would argue to close the case, but now I know better because he's probably also invested in, some monetary.
Absolutely is.
So it did not happen. So now I fired the lawyer and I'm going to do it myself. So one of the things I need help with is first correcting my status properly. I already got the FOIA letter from one of the videos you have that I watched. But after that, how next to proceed, so that
with all of the steps that we told you today, you have to understand that correcting your status on the record, it does help because it takes you out of their jurisdiction if you've done the passport. You're out of their jurisdiction when you can prove that you're not a U.S. citizen. Because think about it like this. I told you guys that all court is what? IRS, taxes. And if only United States citizens are responsible for taxes, they can only try what? United States citizens. So at the point that you're proven through the Department of State, you're not a U.S. citizen, that removes their jurisdiction there. And you do the same thing with the case. Get a certified copy of it, pay the stamps on the case because it's commercial paper. I will file a cure warrant and file everything into the case, and the case should, at that point, go away, using all of the things that we said in the beginning of this class.
So what do I do? They refuse to get me a certified copy because I have asked for a copy of the case and they don't want to respond.
You have to physically go to the courthouse, go to the clerk's desk and say, give me a certified copy of the case. And even when you guys are turning in these papers, I've seen people on the polls say, oh, I sent it registered mail. That's not how it goes. You're not to send it registered because guess what? They can get it and still not do it, right? You want to be right there in front of their face. Like I've literally had clients get a certified copy, move over to the side, pull their stamps out, stamp their things. Okay. Now, normally you can get the stamps canceled out. If they don't cancel it with the round stamp, just cancel it yourself. Okay. Make sure you use a blue ink pen and just cancel it. And then go right back up to the counter and make them file it again. Right. And then you're going to ask them again for another certified copy of the case to make sure that it stays in there. So it doesn't matter what type of court case it is. This is just their rules and procedures because of the status that they hold, which is a corporation doing business under the IRS, and you're actually being charged with IRS fraud. Now, do you have a marriage license?
I do.
Get the marriage license authenticated as well on the state and federal level, which will prove that that is a true document. And then you can also file that in there as well.
Okay, when you say cancel it with blue marker, what do you write? Because the ones I did was just from the post office. But if I'm doing it myself, please, what do you write on it?
I mean, you can go back to the post office and do it, but if not, you sign your name and the date on there.
Okay. Last question, please. Is there any way to get into like your library of, all the things that you're helping us with, so that is there some subscription for it so that I can gain access to it and begin to really study?
No, I give you guys everywhere where to find the information at. I'm using their log. I don't use any outside books. I've read them, but I match up whatever I read back to their wording, because their wording is what matters, because you're putting it back in their face. So every class that we do, we show you guys, or we tell you what law it is for you to be able to go and dig a little bit deeper.
Thank you so very much. I
My
appreciate you.
library of papers probably got like 2,000 files in it. You'll never, and they ain't organized either. I just know how to get to them or whatever. But yeah, that's how you do that. Do it. It doesn't matter what kind of case it is. Now, if you guys are dealing with a court case and you are being sued by a debt collector, let me show you guys what you will file into the case.
And hopefully y'all are starting to understand why this is our favorite class, because there's just unlimited amounts of sauce to drop on this subject. And there's so many ways to go about it because these people are really frauds. Okay. The highest fraud in the land. And there's nothing that's more fun to me than exposing that and making these people fold.
Okay, so if you're dealing with a debt collector and you have a arbitration clause within your contract, and that is 99.9% of them, okay? You already know what to do with an eviction, okay? Under 9 USC 205, removal of cases from state court, okay? When the subject matter of an action proceeding pending in a state court relates to an arbitration agreement or a award falling under the convention, the defendant or the defendants may at any time before trial remove such action or proceeding to district court. That's one, right? You're going to do a removal of cause, and here is what the petition that you're going to file. Now, when it comes to a mortgage, while I'm pulling this up, the mortgage within itself does not have an arbitration agreement in there. Okay. But that mandatory insurance that's within the that they make you get, the house insurance, has a arbitration clause in there. So you would use that as your cause to be able to get a mortgage out of, to get out of your mortgage.
Yeah, you do what is could be called a motion to abrogate the venue. And that's what you do to change it over. So if you're battling in state courts on a mortgage, what she's saying you can pull it into arbitration underneath the provision in the insurance agreement that you had to sign. And then you can use that to segue into the entire mortgage fraud.
Okay. We all know what, if you guys have heard me talk about the FINRA, which is securities fraud. If you're dealing with a debt collector and they are a public traded company, they fall up under the FINRA. Okay. So you would do a motion to dismiss. It's a request made by a party to the arbitrator or the courts to remove some or all of the claims raised by another party of the claim. They have different codes. If I was you guys, I would read them. The Code of Arbitration Procedure for Customer Disputes. So you are able to remove your case out of state court due to mandatory arbitration. So if they suing you, or if they've already gotten a judgment, okay? If they already got a judgment and you're being garnished or whatever, the title of your motion will be a stay of judgment due to mandatory arbitration agreement. You will go and find the arbitration clause that's within the contract, and you will put that into evidence with it, and that will stop any of your state cases. Okay. Christina?
Hello, can you hear me?
Yes, ma'am.
All right. With the HOA, I have a court date on the 23rd regarding, I'm assuming it's going to turn into a judgment. But regarding that, when I did the research, our HOA is a non-stockholder, but it has a partnership with another entity that has control of the actual contract agreement. And I looked for arbitration and it did not have the arbitration in there. And when I dug deeper into the EGR, it had another Salem Field Inc., which then it's two different addresses. So I'm kind of confused as far as which direction would I go with that. And I used to be on the board of directors for the HOA several years back. And when I looked at some of the documents, it still had my signature on there as far as part of some of the agreements that we've established. But nevertheless, it's recorded in the state of Virginia as a non-stock entity, the association. But the partnership that it has, it's a corporation within the state. And then the entity over that partnership is Salem Fields Inc., which does have an arbitration. It also has an arbitration in the agreement with inside the partnership, but not of Salem Fields and the homeowners, if that makes any sense.
Are they suing you? What are you attempting to do?
Well, I was attempting to have it dismissed if I can go in before the 23rd and file a dismissal or something of that nature, rather than actually, go through the whole process on the 23rd. But what's your advice or suggestion, or even having to go about in that route, considering that I don't understand that partnership and how to trace where to go from there, like how to actually
So-
combat it.
So are they attempting to sue you, is what I'm asking?
Yes, yes, they're for the I believe it's like several months, like about 6 months or so, and then all the late fees and fines accumulated on top of that.
So why didn't you just stamp and pay them?
Prior
Like,
or
it's-
now? Well,
it's-
what's the worst
even
worst
now.
case scenario? Worst case scenario on I believe it's what the 23rd on Wednesday. Worst case scenario, I'll just go ahead and pay them.
Yeah, I mean, you
That's
could have
what I'm
stamped
looking.
and yeah, you could have stamped and endorsed that. And due to the fact that it's considered a bill, you can step it and endorse that. You can put a quiet title on your house.
Well, yeah, and I've done the UC-11 for the state of Virginia. Thank you for bringing that up. UC-11 for the state of Virginia. There's not a lien. There's nothing on there, so I'm waiting for the authentication to be sent to me. And Spotsylvania County is the one I'm in. I said, well, let me double check to, double make sure. And they said I have to go there to do the UC-11 to confirmation. So that's on the agenda for next week to do that.
Right.
So get the quiet title. What I was reading,
Do
the quiet title. A quiet
Because with the
title.
quiet,
Go ahead, I'm listening. It was just saying, if I'm understanding it correctly, it's going to take a longer process than within the time frame that I have, the 3 days that I
once
have,
you
or
put
2
a
days.
once you put a quiet title on the property, now everyone who's saying that they have a financial interest into your property has to prove that, and nobody can. So it literally stops everything. A quiet title is nothing but making sure that it's filled out properly, and then you take it and go put it on the record at your county's office. So that goes from the bank, the HOA, or any of the such now have to prove that they can lawfully collect the debt from you. You could also 1099 your HOA. I've had a couple of students 1099 their property taxes. They 1099 their HOA fees and things as well. But at the point that you pull your mortgage contract into arbitration due to the fact of the insurance agreement, that falls up under everything, the HOA and the whole 9 yards. But we know that these people are sneaky. A lot of these states are non-judicial states, which means they don't have to go to court to take your house from you. But at the moment that you put a quiet title on there, they can't do anything. Like, quiet titles have literally been put on a property the morning that the sheriff was about to auction it off of the steps. And you put a quiet title on there, it stops it. Because now you're demanding, just like with the court case that you do the cure warrant on, right? You're demanding that they prove that they have the legal right with a quiet title on a mortgage property. Now the bank and anybody who say they have financial interest now have to prove lawfully that they have it, and they never can, and they won't. So it stops all judgments. It stops any court cases, because now you are demanding that the HOA prove what they say. And if you have a physical contract with the HOA, that means, because it's an amount on there, right? Anything that has an amount for you to pay is a security. Stamp, endorse, or send it, 1099, A it, if that's what you choose to do with that, because it's an active account. So you don't see it, you 1099, A it. Okay?
Okay,
And just
1099.
do that.
So it's irrelevant that the first contract that I've run into, it doesn't even matter that it doesn't have an arbitration clause in it.
No, it doesn't, because you're not removing it. You're the contract. If you have insurance, that PMI insurance or whatever, that's where the arbitration clause is. It's a part of the contract. So you can pull it up under the insurance, which pulls the entire mortgage contract under the up under the case now, which now they have to prove, and it has to go under the FINRA because you're dealing with a mortgage company that is a publicly traded company. You get where I'm going? So you're using one thing to pull the entire contract up under scrutiny, but you're protecting yourself, especially if you're in a non-judicial state, by putting the quiet title on there. It can do nothing, guys, nothing.
And two things to remember on that. If it is not a security, if it's not a negotiable instrument under Article 3 of the UCC, it must explicitly say so on its face. And secondly, in order to have a perfected security interest, go under Article 9 of the UCC, Secure Transactions, and it tells you that in order for them to have a perfected security interest, they must have a lien and another document. And if they do not have a lien, they cannot prove perfected security interest. So when you go put a quiet title on there and you have a certified UCC 11 showing that nobody has a security interest in your home, they cannot prove it. So just a little bit on that to help supplement your understanding. But yeah, as you can see, it all works together.
And then you want to definitely do an acceptance of your deed. Y'all got these deeds and these titles from these people, and you never went and accepted it.
Yeah, your name ain't on it. Double check that.
If you look in your mortgage contract, you turn from a home buyer to a renter. Look in the part that talks about covenant. It calls you a renter. Okay.
I'll dissect that a little bit further. Thank you.
No, I don't want to load nothing. What is it doing?
Okay.
You're welcome. Joey?
Thanks. Can you hear me okay?
Absolutely.
I have Bank of America, and they took away their mandatory arbitration clause in 2009. I've had my credit card since 1999, and they sued me, and they have a final judgment for $32,000. I did a motion to vacate judgment because they didn't have personam or subject matter jurisdiction because they got me for breach of contract, but they never entered a contract into the recorded a contract. So I kept on, nailing them that way, but it didn't work. So now I've done a mandatory arbitration, like you told me, but I can't put it in. I can't include it. All I have is about 5 news articles I found online saying that they took away their mandatory arbitration clause in 2009, and I can show from my credit record that I had the card in 1999, but I can't really show the arbitration clause. And this guy's already thrown out a motion dismiss, motion vacate judgment, and there are like 5 or 6 irrefutable things that I had down there with all the case law to support it. So I think he's just going to steamroll through me and just say, denied. I don't even know if he reads it. He just says denied.
Because you're in the wrong court.
Yes.
You're in the wrong court.
Because the security should be in federal, right?
No, it's not even federal. Federal is just a higher level of tax court because the number is more, right?
Okay.
Even federal is not the correct court. So the mandatory arbitration clause, this is what when they say they removed it. Mandatory arbitration is every one of your contracts. They do that so you can stop taking them to equity court and say, you agreed that we settle it through arbitration. They will even suggest, they never said you had to file it through the AAA. They just suggested that they file it through the AAA, right? But even under the AAA, it's the wrong jurisdiction. So what you do is you remove the case. You do a removal of case due to wrong venue. What is your standing? What company is it? Wells Fargo? Discover?
No, it's Bank of America.
All right. Bank of America is a public traded company, and according to the FINRA and their security agreement, this has to be in a court of equity and law, which is arbitration under the FINRA. It doesn't have to have an arbitration clause on there for you to take it to arbitration, but it has to be done under the FINRA, not the AAA. And the only qualifications for the FINRA, it is mandatory if they are a publicly traded company on the stock market. That's what pulls it in there. So do a removal, and even if they already gave you a judgment, do stay of judgment to wrong venue and a civil 60 fraud against the court, because they knew that they could not try that case. and then file it up under the FINRA.
Okay, and then I just out of curiosity, because I do have the final statement from Bank of America with the, you know, the bond and the payment still attached to it and everything. Is there anything I can do with that? Or is it, I can't do a 1099-A obviously because it's over 3 years old, but is it,
They discharged it off, so you can do a 1099-C. Is it considered a charge off now?
yeah, on my credit, it says it's
Charge
been
off,
charged.
right?
Yes.
Okay, so because it's on your credit report as a charge off, number one, this is how you get it off of your credit report.
Mhm.
According to the IRS publication, all charge offs are considered income. Income cannot be reported to your credit report. Boom, you got it off your credit report. Because they charged it off, a 1099-C was supposed to be printed and given to you because now it is considered income. So just file a 1099-C on it. But
Okay.
if they have a judgment and you're getting garnished or whatever, you can still do a stay of judgment
Mhm.
due to wrong venue, because Bank of America is a publicly traded company. And according to the federal rules of procedure, this is supposed to be in the court of equity and law, which is under the FINRA. Okay, so that's how you get that judgment stay.
And so I'm a secured party, so I already have a lien. I'm not
None of
really.
that stuff don't make a difference.
So I'm just saying, if they try to put a lien on my truck or house or something like that, they can't.
They
do
don't
that.
never, they don't, yeah, they don't ever lien anything. Nobody has a lien. That's why everybody pulls the UCC 11, even when they say that they do. What it is,
Okay.
and when you guys are filing these UCC ones and you're putting liens on your property, it's not the property address that they put the lien on.
It's the
You
land.
better go
Right?
get your title and put the title number on there. For your car, you put the title number on there. It is the titles that they are liening, not the
Mm.
property. So if you need to update that, update and put the title number down on there. Whether it's a car or whether it's a house, your deed of trust has a number on it as well. Those are the things that you want to lien. Okay.
Perfect. And the stamp thing, with just out of curiosity, with the stamp, you know, putting the stamps on a certified case still work for a credit card judgment like that?
It's still a judgment. So that's where you seen that was a writ of judgment. So that's where the 50 cents go. Because it doesn't matter what type of case it is, it's all tax court. So pay the taxes. And you're still able, because you have a statement, you're still able, because you're a holder in due course, to go take it and trade it in. It's yours. That's the part that everybody's, even with your court case. Why you think I told y'all to get it authenticated? Because at the point that it's authenticated, what does it say at the end of the authentication page? This is backed by the full faith and credit. We already talked about the fact that the primary market is the original market that everything goes through first. That's where the bank got the loan from. They used our security, they got the loan, but they only got it at a discounted rate. So then they want to be greedy and take it to the secondary market.
Mhm.
You're a holder in due course. You can do the same. You can go and you can deposit it. It's a security.
So
right?
literally, I can go to the court and get it certified and for 10 cents a page, and it would still work on this $32,000 case.
It doesn't. So y'all have to get out of the mind frame. Is this case or is that case? It's not about what kind of case it is. It's about the fact that there is a security on file, which is your court case number, which was turned into a municipal bond. You want to get it certified to show that it's a true bill. Like when you get that certified stamp, it says true bill copy on there. And if you know what a bill means, right? You know that you now just have a security. You can't trade securities that are not authenticated because they need to make sure that it's real. That is the point of authentication. They're now saying that whatever this document is attached, that's why they say don't detach the authentication from the actual paper, right? They say it with the birth certificate. You see it says on there, because now they're telling you that it's an act of security that you can reap benefits off of. So you got
Thank
three
you.
things. You're welcome. Child support. Child support, child support, child support. Did you guys know when they updated the Bankruptcy Act of 1999, you can discharge child support under a bankruptcy? So in cases of emergency, you get picked up, you in there for child support, have somebody file bankruptcy, you'll be out in an hour. Okay? You do the same thing with your child support case. You go pay the taxes on it. Get a copy of the order. make sure that it's certified, pay the taxes on the case. Mothers, you will still get your check. It just will not be coming out of daddy's paycheck because it is a grant that come from the state where they took money out of your trust account and out of mom's trust account, and they are supposed to pay that back as the bank's supposed to pay the treasury back, but they're in turn making you pay it back. It is a grant. Okay, so you can stamp the order that was given for the child support, go down there and get a certified copy of your order. You can stamp it, okay? Because it is a federal grant that came from the treasury. You can also file a 1099-C on your child support because that is a debt that was canceled out. So I'll give you guys an example. You know how Congress vetoed Biden's student loan bill? Y'all remember that? And the Democrats got y'all all mad talking about Congress don't want to help us, right? They play us all in our face and play us against each other, and they together. So the reason that Congress vetoed that bill, if all debt, right, is backed under the primary market, under the full faith and credit, and that debt, student loan, came from the federal government, Congress said, wait a minute, why are we forgiving things that you guys already forgave? Y'all got it? Which is why when you file the 1099-C, they immediately take it off. It was already forgiven. That's it. What these companies do is, don't forget you're the lender, right? So that's why if you're filling out a 1099-A, you are in the lender box, right? Because you lend them a security, right? They are the debtor because you lend them a security. They took the security to the primary market, which is the treasury, and said, we need some money on this security. Who was the lender? You were, right? But what they're supposed to do is then file the 1099-C, switching roles where you're the debtor now, they're the lender. They never filed it. So it looks like you actually owe these things. That's what your income tax is actually. When they say you owe, it ain't got nothing about you ain't getting them enough money. It's about all these things these companies have filed on you. And they never filed the 1099-C. Anything that is government related that's coming from the federal government is automatically discharged. It will be the 1099-C. Okay. Let's see. But that's why they vetoed the vote, because they said, wait a minute, these were already discharged. So why are you coming trying to get a bill talking about discharging some child support or discharging student loans if it was already forgiven? Same thing with SBA loans. Who did they come from? Straight from the treasury. That is backed by what? The full faith and credit of the United States. So when they did that loan forgiveness, they played with us. They made us feel like, oh, they doing something. No, they had to forgive it because it came from the treasury. They came back, right? Try to make everybody pay that back when the treasury already knows that it was discharged because it was backed by the full faith and credit because it came from the federal government. Okay. That's how that goes. Any case, certified copy, 10 cents on the back. Okay. If you are actively in court and you there and you have to stand there, this is something else that does work. They make you swear in, right? And they make you swear in on the Bible. You can say, talking to the judge, excuse me, Your Honor, no disrespect, and don't be up there with no attitudes. Be just as humble as you can be. Excuse me, Your Honor. I have a question. Are you judging me? They gonna say yeah. Now you just put your hand on the Bible, and the Bible says that only God can judge me. So you can ask him, are you God? He's going to tell you no, and then use the scripture that says only God can judge me. I've seen several cases get thrown out with just that. Because you swore on the Bible that whatever is in that Bible you are attesting to. And that is one of the scriptures that's in there. So when I tell y'all this is spiritual too, it is spiritual. So in between asking them for their law license and asking for a case to be adjourned, until they can provide the law license that you know they can never provide you. Proof, case be gone. Doing a cure warranto, asking them to prove that they have jurisdiction, case be gone. Paying the taxes on the case, just made your hands clean. You guys seen it under the UPU treaty yourself. What did it say? It tells you how many cents that you have to put on that case. And if you want to trade the case to now make your own money, your bid bonds and all these wonderful bonds, then that's when you will go through the authentication process to get that full faith and credit stamp on there, your Q-sub number that go to it, and go find you a brokerage firm and say, look, this is what I got for you. How much do you want for me? Or get that relationship with them and go and deposit it. That's it. If it's an eviction or anything with the writ of possession, it's 50 cents. You just tie their hands. Because guess what? Now they can't trade it. You paid the case off. If it's arbitration involved in it, or even if there's no arbitration clause, if they are a federally traded, if they are a publicly traded company, which means they on the New York Stock Exchange, that is automatic arbitration under the FINRA because it is labeled as securities fraud. If you already got a judgment, that's how you stop it. If you're already on probation, you've already taken a sentence, do the same thing. Go in, put in your motion to rescind your plea under a civil 60 fraud against the court. Throw that cure warranto on there. Throw all of everybody that's down there, the New York District Circuit Court, that's what you write. Whatever judge signed off on it, that's what you write. Do a freedom of information request through Chris to show that they had a financial fiduciary interest into your case. Because what happens is then they will get audited and they'll show that they're not paying taxes. Because I said they give them that extra money off your case and it be put in the lunch fund. Like we pulled one time, and the judge, I'll see if I can find it. He had $300 and some thousand that was his lunch fund. Well, what the hell does he eat? What, $300,000 worth of food a year? But that's how they hide it, and they're not paying taxes on it. Okay, so it doesn't matter what type of case it is. Stop looking at it being a case and look at it for what it is. It's tax court. And put them in a corner by getting the certified true bill copy, paying the taxes, refiling it back in. The cure warranto scares every last one of them. Turning that case around where you're the plaintiff and they're the defendant. And then that's when you can throw in them Title 18s and everything else to prove that they're fraud. They will get rid of the case very quickly. If you're trying to get somebody out, get POA and do the same exact thing on their behalf because you can. Okay. If you get pulled over, you get stopped, you get put in jail. Let me tell you something. If you don't sign nothing and say nothing for 3 days, remember I told you they do everything in threes, they have to let you go. Why you think they say they got 3 days to get a warrant? Ain't they? We know we got 3 days, 72 hours to get a warrant. Well, 72 hours breaks down to 3 days, right? If you don't sign one thing, in 72 hours, because you didn't give them the right to charge you. Also know that if you are fighting a case that you actually did go, you can add into your complaint that if they searched you, that it was considered rape. Their law says that they have to be a licensed medical professional to search you. If it was more than one officer, with the bend over and cough 3 times, stop playing like we ain't been there, okay? It's considered gang rape because it was more than one. We have to use their rules against them. I've not seen one time it didn't work, but I will tell you guys this and forewarn you. When you are playing with these courts, you better do it right the first time. Don't leave them no room, right, to try to switch a judge on you. I've seen people not go all the way through. They didn't change court dates and didn't tell them. They didn't got arrested. It's a lot. So when you go after them, you do it right. And it is just as simple as paying the taxes on the case, making sure that it get put back in there. And another thing that you can ask them in your complaint, did they get authorization from the Secretary of State to try you. Because they have to get permission from the Secretary of State to try you. Period. Because they took the oath there. But you can stop all of that because everything starts with a traffic stop by getting out of their jurisdiction, giving them that damn license back because you ain't no migrant farmer working in agriculture. Okay, that ain't the state vehicle, it's yours. Get out of there. And then it's nothing that they can do. They hate it though, because they can't even pull you up. If you have been arrested and your charges got dismissed, it's still on your record, right? They pull it up, you were stopped on such and such day, even though it did not lead to arrest. This is how you get those removed. You go and get a copy of the discharge, the dismissed case. You get a copy of the complaint showing that the prosecutor dismissed it. You take it down to the local police office that took your fingerprints. Give them that and tell them to give you your fingerprints back. Because ultimately, according to the NCIS, first of all, taking a mug shot of you before you are convicted is illegal. Second of all, unless you are a child molester or a rapist, those are the only names that's supposed to be in a criminal database. So that is a way for you to get it removed out of the system. Okay. Emmanuel, you put that big sign back there. I need you.
Hey, how you doing?
Amazing.
Well, I'm currently in the court case, and I go on the 30th. I didn't get my court case, my copy certified, and endorsed it and stamped it. But when I went to the back to file it in the court office, back to the court, they told me I couldn't file it because it was already filed, and they don't have no idea what I was talking about.
That's when you ask for the court clerk, okay, the head court clerk. And if they give you an issue with not filing it, the moment that you get the state authentication on there, they have to refile it. They'll refile it then.
Okay, so
but
now
don't let them tell you no.
Okay, so now that I fired my I fired my lawyer, and then I go get another copy since I already got this canceled out, and then wait on my authentication because since they're not gonna file it.
If they don't file it, just get the authentication. Normally with the state authentications, depending on your state and the time you get there, they normally have it done for you that same day, if not the next day. And then that's when you take it back down and file it back into the case. And in your case, definitely do a puro warranto on them as well.
Okay, a puro warranto.
And then, I ain't finished. You had an attorney. When you guys have an attorney, give them a W-9. Make them sign it because they not paying taxes. Make them sign a W-9 form. Send them one.
Okay. And I have arbitration with you on the 18th, so just in case I don't do my remedy right, would I be able to have my girl send an email to you or something so she can get the call?
That's fine.
All right.
That's fine.
Thank you, Queen. Have a blessed day.
Thank you. You too. Jemiah Cox. Jemiah Cox. You got me. I guess you
I'm
left.
sorry, my bad. Can you hear me?
What's up? I can hear you.
Okay. All right, so I got I just went through a previous child support case the last couple of months. Now I just heard you say that I guess the easiest way for me to just get rid of mine would just be the 1099-C it. But
you can do the 1099-C, yes.
Okay. So with that, how do I or how would I find like an EIN number for child support? Because that's one thing that I've been like having a hard time with.
They definitely have one. They're a subsidiary up under the state.
A subsidiary?
So, yeah, they're a subsidiary. So the head of child support will be the Department of Revenue for your state. Start there. And then you can also take you have a copy of the child support order.
Yes.
You can stamp, endorse, and send it to. It's a bill.
Okay.
So you can do both 1099-C and you can stamp, endorse, and send it. And because there was a supposed to be court case, right? Because those are not judges at all. They're referees. They're not judges. So with that, you can also put the stamps on that as well, the regular postal stamps, and file it back into the case as well. And if you have to do a defense for it, you can prove to them via the Title IV Maternal and Child, the Child and Maternal Act, that all child supports are grants for the state. So think about it like this. Remember, I just told you under the 1999 Bankruptcy Act, they changed it, they added some additional things from the 1933 one and in 1999. If child support was not a debt, why would they allow you to file bankruptcy on child support?
Okay.
Think about it. So you can do that just like any other debt, step, endorse, or send it. But because now you're dealing with the court, make sure you get the certified copy of it, the true bill, throw those the stamps on there. And in that case, I would get it authenticated on a state level to prove that it is a security. Okay. And then I will go file that back in there. The mother will still get paid every single month. It just won't be coming from you. And it'll take away any arrears, and then they will update your credit report as well.
Okay, because I got it. It's not on my credit report. It's just like I said, it's just I was dealing with because I was trying to get the entire child support thing dismissed, like thrown out entirely. So I was dealing with both child support directly and then in family court. And I just got it like a crazy increase or whatever. So I'm fighting it.
Well, you know, your increase is because they took the original case, right? And because it's backed by what? The full faith and credit, they ran it through the primary market, which is a loan to them. Okay. That is a loan to them that they are supposed to pay back. Everything we are being told, well, that we're giving them permission saying we'll pay back, is what they owe the Treasury for borrowing that at par amount. So every time you go up, that means that the amount of your case is now bigger and you owe more interest on it. And you told them that you will pay it when it's really their responsibility. Okay. Wow. Because they never filed the 1099-C after they ran it through the primary market. The United States backed it by its full faith and credit. They still have just the 1099-A on file where you're the lender and they're the borrower, okay? And so look in the system, it does look like you owe that, but technically you don't.
Okay.
So file the 1099-C on it. Stamp, endorse the contract within itself. And yeah, it's also, child support is also unconstitutional as well, which is another reason why it can be dismissed. But like I said, never try to fight the charges. Okay. You would never win that way. You use their policies and procedures and the way that they are supposed to be handling affairs the same way. And then you can also FOIA that case or go into like Edward Jones or something. It's a municipal bond, y'all. Don't go in there talking about the state. It's a municipal bond. Can you run it? That's it.
I had heard you mention that FOIA form before. Like you had talked about that on one of your lives, like maybe a month and a half or so ago. And I was wondering with that, is that something that you would send directly to child support as well?
If you go under your state child support thing and just put in FOIA, it'll tell you exactly where to send it. They probably already have a form up there for you too. We have the right to do a freedom of information request for any of this. And you know why we have that right? Because they have government contracts, which means it's public. So they're supposed to, anybody can get that information, and that's how you get it. and sending them affidavit and all that don't work. But a FOIA using their documents, it does.
Okay.
Right. And then once you do get the Freedom of Information request back, or you get the QSIP number because you ran the municipal bond, then at that point you get it authenticated. So now that you can profit off of it because now you're a holder in due course. Y'all understanding it? Like
I hope they're
case,
getting it.
I hope they get it because it's literally that simple, guys. I know it may not. It is. Every case is a bond. Every bond is a security. If you got a true bill copy, you a holder. You can sell it just like they sell. Point blank, period.
Okay.
Okay.
And when it comes to child support, another thing you can use, Social Security Act, Title 4, Part D, Section 458. This is incentive payments to states. I would go look at that and understand again, that's how you prove that that judge has a financial monetary interest in the case. Incentive payments to states. And when you read it, your mind is going to be blown.
Yep. And you can also use the case Holman versus Holman. That is the case that they said that child support was unconstitutional. It's Holman versus Holman.
Okay, I got a PDF copy of that on my computer.
Good. Use that.
Okay.
But you just beat them at their own game and just go ahead and, get it discharged off that way. And when you do the 1099-C, do it for the full amount that they say that you owe. If it's $600 a month times 18 years or whatever, put that full amount, but also add what you've already paid them. Okay. So what that does is put an overpayment on your account. Now they now have to distribute to you.
Okay.
Okay.
I'll do that tomorrow. I gotta find the EIN, but yeah, I'm gonna do that tomorrow. Thank you.
You are more than welcome. You'll find it. And also pull your state charters. You guys go pull your state and your county charters.
State, county charters.
It will tell you a lot. That charter will tell you that exactly who the course is, that is taxable. But U.S. citizens are only responsible for taxes. That's why you're going to stop saying you're a U.S. citizen and prove it. Now you just remove their jurisdiction. Because like I said, when y'all dealing with these courts, you have to do it right. And I'm telling y'all from experience, okay? Experience. I got out of a ticket with a cop, okay? And that man looked at me because I won and said, I want you out of this state. The next thing I know, every time I turned around, that cop was messing with me. So that wonderful mugshot that everybody like to put up, like I ain't never said I was peachy cream. But I tell y'all is that everything that you guys have been through, that you're going through, I have been through it. Yes, I did take a plea in the beginning because North Carolina wasn't playing no games and I got to go home to my babies. But this is why I can tell you that you take that plea so you can, and then you run it back on them. Okay. But if these cops do not like to be beat. So you have to do it right the first time so that you will not become a target. Like I became a target. Every time I turned around, they were there. I was like, damn, do y'all got a tracking device up my ass? Because are you serious? That man said, I want you out of this state. And before it was all over with, and I looked at him and said, and I'm going to have your job. And sure enough, I had his job. I took that plea in the beginning so I can go home to my kids. Okay, they need me. I'm not about to battle these people like that. But I'm able to tell you guys how to do this because I physically went through it myself. Okay, and ain't ashamed to say it. But I became a target. Do not become a target. You want to tie their hands in every corner so that they know, okay, we can't mess with her. First of all, we can't pull her up in UCIS. Why? Because the Department of State has you down as a living person. So that stops them there. And once you put a cure warrant on file with the court, no, you'll get a letter back. And they'll say that no judge will take this case. If you have no judge to take the case, what can they do? Nothing. If you have no clerk that will sign off, because now that's everybody's job. That's why you get the court clerk by making her put that true bill copy, because our signature in blue will be there. When this live is over, I will post what it looks like on my page so you guys will know what a certified copy looks like. Okay? If you going, like I said, and if you're going through an active case, do each step, including getting your birth certificate, a copy of it, and put paid to the order of. See, she has one. Y'all see hers is certified. Look, Naima Lewis, can y'all see that? You see where it says certified copy, true copy? That's what you need. And her signature is in what color? Blue. Because blue means a lie. So now she's liable, which means if they don't do what they're supposed to, you can have their job. Do not let these people tell you you cannot get a certified copy of your case. If they do, make sure that you do the cure warranto. That will stop that. Show the fiduciary duties that they have and go hand deliver it down there to them, okay? If you have to go that route, you're gonna hand deliver their copies and things to them, but the physical judge that is over your case, that one you will send register mail straight to them, okay? As I stated, if you got charges on your record that need to be removed. Oh, if you're in one of the 12 non-disclosure states, if you have a record in any of those states, that particular state has a form for you to suppress it because it's a non-disclosure state. They were only allowed to post it because you signed off. So you do not have to wait for an expungement. You don't have to wait a certain amount of years at all. It doesn't even matter what type of case it is. The only case that does not fit that is things dealing with children, as far as, you know, rape and things of children, right? But any other case, if you're in a non-disclosure state, one of the 12 states, file the appropriate document that you will find on your state's website, fill it out and turn it in, and now you have an order. The only people that will be able to see it will be prosecutors, but anybody as far as the public, they cannot see it. Because you know how many people are affected by being at the wrong place at the wrong time, or just the fact that you got arrested. Because now these reports show every time you've been stopped and everything, they're showing all of that, and that can hinder people from jobs, even though, you know, you wasn't convicted. Why have to go through explaining? They'll just automatically say, no, you can't have it. So that's how you get that off. Dismiss cases, get a copy of the disposition saying it's dismissed, go down to your local police office and sheriff department with that paper and say, I need my fingerprints back. And they'll physically, the little card they put your fingerprints in, they're gonna physically give that back to you, and it removes it out of the system, okay? And Tad?
Hey, how's it going?
Amazing, how are you?
I am excellent. This is incredible. Thank you.
Thank you.
I just have it can be pretty quick. I'm up in Canada here, so, or on Canada as they say. I'm just wondering in terms of like the stamp duties, is that going to be similar for us here? Or is there somewhere else I can be looking for information like that?
It is absolutely similar there because Canada has a contract with the United States. And inside of the Treasury office in the United States, there is a whole Canadian floor.
Right.
Because of that contract that they have, yes, it does apply the same.
Huh. Very cool.
Yes.
That's all I wanted to know. Thank you so much.
You're more than welcome. Exeter Miller. I don't know if I pronounced that right. If I didn't, I'm sorry. I can't hear you, darling. Unmute.
Can you hear me now?
Yes.
Yeah. Okay. Okay.
Wow.
It's X-ray, but thank you. Thank you.
Okay.
You're welcome.
It's my husband, Wendell Miller, who turned me on to you. So
I've been following you forever. You see my eyes is baggy from looking at all the videos. Nevertheless, I got stopped in Arizona like in 2016, and I was trying to get a license because mine is about to expire because I'm waiting on the whole FOI form to come back. But nevertheless, they say I got like a $500 ticket or whatever that I need to pay before they can release my license or whatever. I guess they got a lien on it. It's a DMV. And I'm trying to figure out, I mean, I asked for them, like, do they have any court documents? They only sent me a ticket, and I don't know how to proceed because I don't really think I should pay a ticket from 2016 that I didn't even sign for the ticket that this trooper stopped me for.
So the DMV is holding your license. The
They
best
won't
way.
Yeah.
Go ahead. What was you about to say?
Well, I had a California license and we moved to Illinois, and I'm trying to just not have my license expire for my job and whatever in the meantime before I can declare my national status.
Okay. Do you drive? Do you need your license for work purposes?
Not necessarily. It's a form of ID, and it's a California license, and I was trying to just transfer it over here to Illinois, but they said they couldn't do it. But the other end of it, I had an Illinois license before, so going through it, Illinois granted my license, they just won't actually give me the physical card.
Until California releases it, right?
Until Arizona
releases it.
Yeah, we made a trip across the country, and I got stopped in Arizona for no apparent reason.
So the best way to get out of that is I will do an affidavit to the DMV advising them that you know that they are selling your information to non-governmental entities and you need a printout copy of it. They'll move you out of your system so fast. That's it.
Wow.
They will. And you guys can do that for any of your licenses, right? If you don't have the passport yet, getting a state ID card does not put you up under their jurisdiction as an employee like the driver's license does. No,
so
it doesn't.
I got a state ID. So if I just receive my driver's license, I should be okay?
Correct. Just use your state ID and then make sure you update your passport card. So that's your right to travel. But if you tell them that you know that they're selling your information to non-governmental entities and that you need a copy of that, they will put you in the system as don't touch this. Leave them alone. Your plates will always be updated. Like they'll automatically update them. You won't need a tag, but they will move you out of the system because of that. And definitely when you rescind the driver's license itself, if you're like me, I'm on my third state that I'm living in, right? So I rescinded my license in every state because the way that they're doing, their systems is connected together under the Highway Public Safety Act. Okay. That is how they're able to link, oh, you owe this state, we can't give you one. But the Highway Public Safety Act also says that when a private person requests, they are to give them private tags. That says private. Because right now you have tags that belong to the state as a 1099. You can also, in that letter, whether you know they're selling your information, you can let them know that they have you classified as a 1099 state employee, that they are receiving grants from the federal government, and that you need copies of all of that. Because technically, if you have a driver's license, your state owes you because you're a worker. They owe all the maintenance on your vehicles. This is why they can call and get it towed, because they technically own it, right? Because you registered it to them. But they have you down as a 1099 state employee as a migrant farmer worker in agriculture. So you're able to put that in there, and you can tell them that they're selling to non-governmental entities, that you want to be removed from the system, and whatever your state rescission of driver's license looks like, you will fill that out, turn that driver's license in, and revoke their power of attorney that you gave them. It's just like a job. What? Once a year at a job, what do? They
tell you, they give you a review. How you did for a year.
There you go. Same thing with the DMV, right? Same thing, but as long as your car is registered to the state, they owe all the maintenance, they owe the oil change, they know the tires. Start sending the DMV bills since you're a 1099 employee.
Okay. I got one more question, right? So I did the whole thing with the trying to put the title of our car get the title from the DMV. I did the FOI record. The UCC 11. I did the UCC 11 search, and I took it to the DMV and I requested for the title. and they told me I need a actual letter from DuPage Credit Union, which we can't find. But I'm thinking I watched the video prior to this, and I think I got an idea to find it. But they said they need an actual letter from them to release the title for us.
So what you do in that case is that you do have to request it from the lien holder, okay? So you will draw up a notarized letter. You will get it notarized. They have 21 days to respond to you. If they do not respond, under the Secretary of State rules, it says that as long as you, under oath, which means raise your hand and say that this debt has been paid off, you have attempted to receive the title from the company, they have not complied within the 21 days, you can do an affidavit under oath at the Secretary of State saying that you know that this debt is that you're no longer liable for this debt, and they have to remove it.
Okay.
Okay.
Awesome.
Thank you so much.
Thank you.
You're
Thank
more
you
than welcome.
for doing, because you're amazing. That's it. I'm sorry, I'm not going to hold you.
Oh, thank you. Janetta?
Hi, I'm so
Hi.
excited. I'm so excited. I've attended a lot of your classes and I haven't been chosen to speak. I have a quick question for you. Oh, I just want to tell you I love you so much. Like, I'm just so grateful that you answered your call. I'm so grateful.
Thank
My
you.
my question to you is, and also I'm grateful for Caleb as well. My question to you is, I went through a divorce, and in a divorce, he was able to keep his retirement and I got the house. But he was very adamant about putting on in the divorce decree that I have to sell the house by the time my youngest turned 18. And I don't think that's fair, because he gets to keep his money and do whatever he wants with his money. So I was just wondering, like, I guess he'll probably end up he can't wait till my child will be 18 in April. So he can't wait until my child's 18 unless I put the house in my name, because the loan is in his name. So I guess my question to you is, how do I go about that, getting around that? Would it be the same?
You signed a divorce decree?
I did, but I wasn't happy about that.
It's a contract. And then if the house is technically in his name, but the good thing about it is, because the house was acquired through the marriage, it's 50-50. So whatever he sell it for, he has to give you 50%. Or see if you're able to take the loan over from him. See if he's willing to do that. Take the loan over from him, where the loan now goes into your name. Okay. That means you got to pay him. I know you don't want to, but
well, actually the house is mine. It was granted to me in a divorce with the stipulation that if I don't have it in my name, then I would have to sell it. And I really don't want
to sell it. So get it in your name.
Okay.
Get it in your name, which means you have to get a mortgage on it or whatever. And so that way it can transfer into your name. Then once you get the mortgage for it, just step endorsing the mortgage, put a quiet title on there, and then now you're good, right? Because if you sell it, you'll get 50%, he'll get 50%. But because that stipulation is in there, that if you can get it transferred over to your name, right? So find out what the balance is, what the balance will be by April, or however the case may be, and get those funds from that, whether you do it as a hard money loan, which are the easiest ones to get, okay? They can do hard money loans, or you can try to take out a physical mortgage on there.
Okay.
So it can be transferred into your name. Then once you've gotten those funds and it's transferred to you, stamp endorsing the mortgage document. So now you are no longer responsible for it. And then when the title and the deed and the mortgage note is in your name, those are all securities, stamp, endorse, and go deposit somewhere. Now you're constantly making money off of it. You still was able to keep your house. He got his little pennies. Because the thing is, whatever the house is worth, that's what it has to be, transferred to you over in. And that's the best way to do that.
With the hard money loans, I can also stamp in, do that as well?
No. So with the hard money loans, because you are basically getting it from a private lender, right? Now you can stamp endorse that contract and go and deposit it into a Fidelity account or something to like sell it, and then you're able to pay the hard money lender back. I always suggest if you're trying to get a house, get a hard money loan. That means that the house was bought in cash, right? After 30 days, do a refi so that you can get 80% of it out, pay your hard money lender, but then stamp endorse send the mortgage contract. So now it's taken care of. So your hard money lender was paid. You got paid because that hard money lender gave you a contract, was as a security, right? And then you went to Bank of America, whoever, and got a refi, which they'll give you 80% of the home value. You pay your hard money lender back, and then you stamp endorse send to pay off the mortgage. But then that's another security and contract you have. Then go and deposit it with the stamp endorse send. We got to think outside the box with these people.
Yeah. One more thing, I had paid for arbitration, the $1,500 for you to help me with that, or I don't know, but anyway, some kind of way I didn't receive my phone call or I missed my phone call. I can't remember what happened, but I was wondering if there's a way I can get back on your calendar. I know it's probably full, but I wonder if I can still get that arbitration.
I'll have to look and I'll send you an email. Normally, if it's a missed call or something, I try to get you back in as soon as possible. I've been working on days that I normally don't work, but I'll look at it and I'll let you know.
It was I think it was in March. I've been trying to reach out.
March?
Yeah, I kept sending emails, but I wasn't getting
okay, I'll look at it.
Okay, I appreciate that. Thank you so much.
You're welcome.
Thank you. I appreciate you so much. You and Caleb. You guys, God bless you guys.
You're more than welcome.
Have a great night.
Thank you, you too. Harold Ellis.
Click off. My question is, I had a case where I went to prison for where we were asked to make a settlement with the courts on some outstanding money that was not bought in for this investment that we were doing. And we had everything when we went to court on that 90th day. They gave us 90 days to come up with $550,000. We came up with the $550,000 via a certified check and then also a letter of credit from Fidelity. And the judge told us that the court is not in a position to negotiate a note. So they remanded us into the custody at that time. So serving the 2.5 years there, when I got out, they still had restitution for $550,000. And now with the interest and so forth, they've transferred it to the California Franchise Board. It's $750,000. So what should I do there?
You can pay the taxes on it the same way, and you can file a 1099-C. Because at the moment that they transferred it, it's considered a charge off. So file a 1099-C on there.
Okay.
And if it's with the franchise board, that is who you will put in the box, the franchise board with their EIN number. Because at the moment that they sold it, it was considered charged off. And you can still pay the, because ultimately whatever they say you owe in a court judgment is the tax amount, right?
Right.
So still do the same thing, get a certified copy of the case, put the stamps on there, turn it in, so that takes care of that portion of it. And then what they sent to the franchise board, which is tax, because your franchise board is taxed, right?
Right.
So that you can 1099-C it as well for the full amount.
Okay.
Okay.
Thank you very much.
You are more than welcome. What time is it? Caleb, can somebody tell me what time it is?
Yeah, it is just past 10. I was gonna say we should be coming across our last questions here.
Yeah, definitely that is it. I know I don't keep you up past 10 o'clock. So just as a recap, arbitration, even if you don't have the agreement in the contract per the law, it has to be done under the FINRA. That is how you stop a current court case for debt. That is how you take a stay of judgment. If you've already got a judgment, you will do stay of judgment. I don't care how long it's been. Do a stay of judgment due to mandatory arbitration, because it's still mandatory arbitration, whether the clause is there or not, because it is a publicly traded company, point blank period. Okay, that's how you do a stay. If you got an eviction, whatever form that they send you, if you got 10 days to respond to it, that's normally the time frame. Put a 50-cent stamp on there, go and turn it back into the case so that the case can be taken care of. Okay. If you have a repossession and they have already came and took your, oh yeah, my battery about to die. They already came and took your car. If they have not sold the car already, you can go file an immediate bankruptcy, because bankruptcy goes back 6 months prior. So whatever bills you owe for 6 months, you're able to add to the bankruptcy, file the bankruptcy to get the car back. Once you have the car back, file a lawsuit against them under the FINRA. That will, while the case is going on, they can no longer come back and do another repossession. Once you've done that, go and dismiss the bankruptcy case that you put on. If you're attempting to stop a case, certified true bill copy of the case, 10-cent stamp, file it back in, add your FOIA with it. The FOIA is like the killer, because if you took away the sheriff's ability, can't nobody arrest you in court but the sheriff. Y'all see that? The police come in to testify. Okay. If the case is real heavy and you feel as though you're going to have issues, make sure you file a Q warrant. Do a freedom of information request under the criminal risk investment system. You can also do the 4506T to prove that they are not government. Authenticated if you choose to. I personally would, but if you're running out of time, you got like a court case next week or whatever the case may be, file everything in there. Me personally, you don't ever give them a chance to try to combat what you're doing. So whatever you file, if you file 10 things, get another certified copy, because now you have sealed whatever you put into the case within itself. If you have court on the 19th, just throwing out a date, I will file all my papers on the 17th. Don't do it the day of, because they won't get it. Your file will already be upstairs. At least 2 to 3 days, maybe 3 days before the actual court case is when you'll go file all of these items in there. When you're doing a curo warranto, you are the plaintiff, and the defendants will be the judge, the prosecutor, the court clerk. But to make sure that you take care of everybody in the court, if it's Kent County, you can put Kent County District Court. If it's the state, you can put the state of California. Like, you're going to add all of them as defendants. Okay. And that is requested. They have the proper right to even have you there. You can also ask them to provide you with the document that the Secretary of State gave them the right to try you, which they never can. If you're trying to get somebody out, do a POA. Make sure you have a POA for that person so you can stand in for that person. You can also take your birth certificate and put paid to the order. If you're doing paid to the order, do it to the Department of Revenue, because they are the parent company. It can simply be wrote on there. And I think that's it. Any tickets are done the same way. Everything is best to be done like within the first 3 days. So if you get a ticket, try to take care of it within that time frame on the ticket, because there will be no certified copy of the case because it's only a ticket in there. So on the ticket, you will also put the stamps on there. Take it back in and file it back in. But it's very important that you guys do the steps and the recording national status. And then guess what? You ain't got to worry about none of this. Because at that point, they can't stop you. You took away their jurisdiction. And now you're not in the state system as a slave. You're not in the federal system as a slave. And now you can move on to the banking side, because one side has nothing to do with another. The banking side has nothing to do with court. It's a totally different system and it's totally different processes. But because you know your court case is considered a security, do what you know. It's commercial paper. So you want to get it certified true bill so that you can now go deposit it within yourself too, and now reap the same benefits that they are reaping. Okay. If you are doing a court case, you will have to go to a brokerage firm that has more than just the Series 7. You have to deal with a brokerage firm that does municipal bonds. And you have to make sure that, because at that point, it will be a municipal bond. Okay. If you got a mortgage and you're facing foreclosure, quiet title on the property, and throw it into arbitration, because one, the insurance clause has an arbitration clause in there. And two, if your mortgage company is a publicly traded company, equity in law is your remedy, which is the arbitration under FINR. So once again, it does not necessarily have to say arbitration clause in there. But if you know what the qualifications are, which means they are publicly traded company, you're able to utilize those remedies. And
any company registered with the SEC, if you read the Securities Act of 1933 and the Securities Act of 1934, you'll know what a self-regulatory agency is, and that the FINRA is considered one of these self-regulating authorities under the Securities Act. So that's where you can understand why it is that all companies publicly traded are in that database and would have to be subject to those rules of law and equity.
If you plan on getting a 4506T, file it now, because sometimes it does take the IRS a minute to get that form back to you. But it's a very good form to have in your possession. If it was me, I would do my local police department. I would do my state. I would do the sheriff's department. I would do the courts, because if they're government, then they're tax exempt. You can even do the DMV. You can do child support. You can do DHS. And all of the letters will say the same, that we have no record of this people in our system. So that proves to you that they are a corporate entity. Their EIN number solidifies it. Okay. Child support, you can file a 1099-C. You can stamp the child support order as well. If you want all of the child support to be over, just stamp the entire, the actual order. Because I don't know, do they still send out coupon books for child support? I don't know. Okay, so they don't any longer because of the Electronic Funds Transfer Act. They just turn it over to a book entry security. But stamp the entire order, and then to stop the judge's action, do the same thing, to stamp, the endorsement, send. I think I will, when I send you guys the replay, I'm gonna be nice. And I will attach the PDF of the UPU treaty for you guys. I'll attach the one from 1863 in there so that you guys can use it as a reference. Just in case they ask you, why did you put a stamp? Take them back to the UPU treaty. And because they are working for the IRS, which is taxes, then now you have your foundation to stand on. So I will definitely add that on to the replay of this video. Of course, you guys will get a 14-day courtesy replay of this. to go over it. And yeah, that would be it. Caleb, you got anything else you want to say?
The only thing I gotta say is that if you still having trouble with court after this class, go back and watch it again.
Yep. Yeah. And please do the recorded national status steps, even if you don't do nothing but the FOIA. But if you know you out here driving, we don't say I'm traveling. We throw them a card that lets them know that I'm traveling, and you remove their jurisdiction. But that does mean
I was gonna say I have personal testimony of people out in Chicago who have said that the cop pulled them over. They gave them the passport card and they said, "Have a good day."
Yeah, because there's no jurisdiction. But it is very important because of the Highway Driver Safety Act that any state that you've had a driver's license in, even if it's expired, you ain't lived there in 11 years, you still have to do a recension of it, because that's what they'll try to pull on you. But you had a license in Michigan or you had a license here, all of them will have to be rescinded. If you go on there, the DMV website for your state, it is there where it asks you for you to be able to turn it in. Okay, to make sure that they comply. I would definitely add that letter that lets them know that they are selling your information to non-government entities and that you need a printout, and you know that they received a grant for you. You need a printout, and then nicely in the letter, rescind any authority that you gave them the same way you do with the recension of your security interests, and tell them to remove you out of their system. You have the right to ask for that. And then you won't have to worry about charges. So that is that. You guys have a very wonderful night. I will get this replay out to you guys very soon. And I will add the UPU treaty on there for you guys reference. Everything in every security for mortgage, it tells you exactly how much it has to be, depending on the type of security that it is. Okay. And I'll make sure that when you get if you get a certified copy of your case, that bond, like if you had to bond out or something, make sure that one has 50 cents on there. Okay, because that's a writ. So you make sure the bond has the 50 cents, the certified copies from the court have the 10 cents. All right. And on that note, you guys have a very wonderful evening, and I will talk to you guys soon.
Peace out.
Peace out.